A proposal was sent by the Deputy Commissioner on 03/07/2014 for sanction of financial assistance to the Additional Chief Secretary, Government of Assam, Revenue and Disaster Management Department. Consisting of 67 persons.
But petition has been filed by only 53 persons.
67 persons. Please note. The however, as of today, no financial assistance has been provided to the affected
Right.
persons in the
Simple injuries were paid, Lordship, as per the instruction
Ethnic-
dated.
rights. I said ethnic rights. Please note. Next paragraph. The state on behalf of the state filed an affidavit stating that admitting that a huge number of people were affected in the said ethnic violence that occurred in the what is this BTAD?
Tentative.
Borderland Territorial
AD,
BTAD.
Borderland Territorial Autonomous District.
District.
Borderland Territorial Autonomous District and neighboring districts during 2012. Mr. Considering the date of the situation, DPTH, the government-wide notification dated 24/01/2013 delegated financial power to the Deputy Commissioner of Procurator Chirag Bongaigaon Dubri and Dubri to sanction financial assistance at the rate of rupees 50,000 each to grievously injured persons and at the rate of 10,000 each to simple injured persons in the said violence, which was valid up to 31/12/2013. It is further stated that after the expiry of the delegation period, Deputy Commissioner, Procurator has submitted the proposal for sanction of financial assistance in respect of 67 members of grievously simple injured persons, members of grievous and simple injured persons by proposal dated 03/07/2014. Mr. On examination, the proposal of the Deputy Commissioner, the department had found a list of 70 injured persons within bracket 757 grievously injured and 13 simple injured. Bracket was without a support of proper medical reports from the competent authority and the superintendent of police. Accordingly, the department has returned a list of 70 persons along with its enclosures in the prescribed format along with relevant documents, which is under examination of the Deputy Commissioner. Please note. This court, no. the learned counsel for the learned standing council MSG has on 12/6/2024 has placed a copy of the communication dated 11/06/2024 informing that the budget for an amount of rupees 1,30,000 has been allotted for payment of financial assistance to 13 members of simple injured persons at the rate of rupees 10,000 each.
Not yet disbursed.
Please stop.
My lord, this, as per the submission
how
of the,
Other in respect of other
ফেডারেল খবর ল'ব লাগিব দেই আমি ক'ব নোৱাৰিম
57%, since there was
ফেডাৰেল খবৰ ল'ব লাগিব
since in respect of other 57 grievously injured persons, no instruction has been received by her till date,
It is under
till
process
today.
as per the latest previous instruction, it is under process, Lord.
Today, however, she submits that in respect of 13 simple injured persons, the amount at the rate of 10,000 each has already been disbursed. All right.
Yeah.
However, not however, and the rest 57 grievously injured persons are still under consideration. Please stop. Mr. Ayat Talukdar, Learned Counsel, you are not the simple injured persons. 13 persons are not before this court.
Lordship, petitioner number 1, Zaharuddin SK is the simple injury. Maybe
Simple
petition number 1 is already paid,
Yes.
Lordship. Jaharuddin SK, the main petitioner.
there is
Lordship.
a simple injury, my.
So
Some petitioners are
have you
paid.
received
Yet, it is not yet disbursed to the petitioner.
next para? Mr. Ayat Talukdar, Learned Counsel for
As
the
per my
petitioner
information, my lord.
submits that. The submits that he has no instruction as to whether some of the petitioners who falls under the who are within 13 simple injured
Yes.
persons have received the financial assistance as stated by the Learned Standing Council. Mr. Next para. Having considered that the petitioners, having considered the submissions of Learned Counsel for the parties and considering that the petitioners are admittedly entitled to be provided with the financial assistance on account of the injury sustained during the ethnic riots in the district of Kokreza, Kamal, in the year 2012. I'm of the considered view that keeping pending of the present writ petition would not serve any purpose, particularly in view of the fact that 13 persons who have received simple injury appears to have been already provided with the financial assistance, and the remaining 57 persons who have received, who stated to have received grievous injury are under, are said to be under consideration since nearly a year. It would be appropriate to close this repetition with a direction to the responsible authorities, particularly the Revenue Department.
Yes.
To expedite the process of consideration by verifying the entitlement of the petitioners as well as other equally situated persons and to provide the financial assistance. This accordingly. It is direct, the repetition is closed.
Preferably within a
With
period
a
of 3
direction
months.
to the responding authorities, particularly Department of Revenue, to verify the persons who have, persons including the petitioners who have sustained injuries in the said ethnic violence in the year 2012 in the district of Cochrane, within a period of 3 months from the date of receipt of this order, and thereafter the financial assistance shall be provided within a period of 2 months. Total 5 months,
Within 5 months, Your Worship.
strictly in accordance with the applicable policy of the state. With which instance of life disposal.
Deeply obliged.
His Lordship.
Yes,
My lord, the matter may be adjourned for 2 weeks because
Why?
my lord, Mr. H. Sarkar, the conducting counsel for the petitioner is not well. He has went outside Assam for treatment, madam. So he's suffering from cancer anemia. So my lord, matter may be taken after 2 weeks
so you are with brief,
on behalf of.
without
Yeah.
brief.
Yes,
You
my
are
lord, I'm
appearing
not.
without brief.
Yes, my lord,
Are
I'm
you
not.
in the are you in the case?
No, no, my lord, I'm not. I'm praying on behalf of him.
So what is
That's-
the matter?
matter may be of devoter matter.
Yes.
Devoter matter, Lordship.
Hmm?
It's a devoter matter. The petitioner claims that he has been declared as a city person of 1966-71 stream, Your Lordship. And accordingly, he claims to have registered himself before the foreigner regional registration officer.
Hmm.
And as per the rule, after registering himself as a foreigner regional registration officer, he is deleted. His name is deleted from the electoral roll for a period of 10 years. After that, his name may be included. Now he claims that his name should be included, and he submitted a application which he claims that it is a certificate of registration. So if that is proof that the document is a certificate of registration, his name may be, the D may be removed from the voter list and his name may be included in the voter list.
Is it not before, is it not a matter to be before the foreigners bench heading the for FT?
Yes, Lordship. Yes, sir.
Huh?
The
Total matters are listed in single bench. Lordship.
Civil matter.
Is it?
devoter matters are listed as single.
Lordship,
If
will
they
take,
come,
take the matter after 2 weeks, my lord. You'll,
Mr. So and so,
that's not, my lord.
no, on the prayer of Mr. Esnar, appearing for Mr.
H. Sarkar.
H.
H. A. Sarkar.
H.A. Sarkar, learned counsel for the petitioner. On the ground that the Mr. Sarkar learned counsel is having some, is under medical treatment.
Yes, ma'am.
Release this matter after 2 weeks.
Obliged.
May I please, your lordship?
Yes.
This matter sure that together issue is similar. Yes. We have received an affidavit in the opposition filed by forest department after a long time. I have to clear some 2-3 points. Yes, I may be allowed each time to file reply to that.
What is your prayer?
Here is a twofold of prayer, my lord. That is why my affidavit reply is very much essential.
No, I'm asking, what is your prayer, sir?
Page 24.
Which case, my lord? Two cases. are
Both
there.
the cases.
What happened, my lord? There we were having meanwhile, we are conducting one citizen meanwhile.
What is
In the
the,
meantime, what happened, my lord? The PIL was there. Then in
Hmm.
PIL, they wanted to go for forest community, reserve community for forest, or bird sanctuary. Then honorable division bench in PIL passed an order taking to take to decision regarding whether this land is feasible or not. They have not taken for a quite long time. That's why I have filed this first, second case. Indeed, during pendency of that case, they have given requisition notice to me, not acquisition, requisition notice to me for handing over the land.
Hmm.
That is why now this honorable court has gone petition that first to decide whether this
land falls under the reserve forest?
or not. That ultimately they have filed this one. They have filed affidavit that is not feasible for forest for bird sanctuary. But another thing is there, they are bringing that, they're trying to bring it, this is a wetland. That is why it comes under wetland rules then it's 2017. But according to me, my lord, this land is not, though it is a wet, maybe little wetland, but it is a agricultural land. Classification land is there. We have-
How do you decide?
no, I will,
Whether
that
it's
is
a-
why, that is why records are there. I have to bring records with by way of filing affidavit because it will be decided on the basis of my reply. Because that documents are with the circle officer. I have to bring on record that this is land for this. That is why I am paying for 2 weeks time for filing because now they cannot come ensuing election, if panchayat election is there, they have to come
The
all along
government
from.
said it's a wetland.
No, that
As
is
per the
to-
rules, you are
no,
not
no,
entitled.
that will come later on. But I am entitled for at least reply, my lord.
No, reply, forget about it. I just wanted to know on merit. Forget, we'll
No, I am not.
we'll grant you,
No,
definitely.
because until and unless it has been decided.
They said
That
it falls
where
under the
classification of
wetland.
land, my lord. Now,
Yes,
humble
Mr.
prayer, my it is today, I am praying for 2 weeks time for filing reply, my lord. It is essential. They have taken
Your
long
reply
time.
may not be required.
It is required, my lord.
How?
It is required.
That's why I would like to know why you want to file a
That
reply.
is why this I have to
See,
bring,
it's a matter of land.
and the classification of land, I have to bring on
The
record.
government has done it. They
Go-
said it's falls
Government
under
has,
the
forest
wetland.
department has gone, revenue has not gone. I have to bring the record of revenue department.
Just wait. Yes, what is your stand?
So, my lord, we have filed an affidavit in item 17, my lord. In
7.
16, my lord, we have not been made a party. In 16, they are challenging the requisition where we are not a party.
Okay.
In 17, my lord, what they are doing, my lord, that is a bit problematic. Why? They are seeking enforcement of the PIL's order, my lord, through this writ petition,
Hmm.
which would have been a contempt, my lord. But nevertheless, my lord, we have filed an affidavit. A committee was formed because, my lord, the prayer is to make a decision as per the PIL's order, what to do with the wetland, my lord. Then we have filed that report, the committee's report, which says that initial plan, my lord, of constituting a bird sanctuary, that is not feasible because the land has mixed ownership, my lord. Some part is owned by railways, some part is owned by private people. And because, my lord, it is a wetland, some importance is there, my lord, ecological importance. That is why the committee had suggested that it can be notified as a wetland under wetland management rules, my lord. But that has not been done yet.
That has not been done.
Not done, my lord.
I have to bring on record.
Is in your favor.
Huh?
Government is, forest department is in your favor.
50%.
So why you
60.
are, why
No,
you
no,
want
no.
to reply?
That is why what happened, my lord. There, one way, one hand they are favoring me, by another hand slapping me. That's the problem. That's why I have to bring on record.
Sir,
Huh?
how sharp your teeth may be, you cannot bite the water.
I am not
There's
doing,
a African proverb.
yes. Yes. But
How sharp your teeth may be, you can bite the water.
let us see what can be done. We have, because they have taken number of days. I am paying for first time. They are replying, they are
Only-
telling about contempt.
On the prayer of Mr. C. Barwa,
My lord,
learned counsel for the petitioners.
in both the cases.
List this matter after 6 weeks.
No, no,
So
no,
as
2 weeks,
to
2 weeks.
enable
After
him
2
to
weeks.
file affidavit in reply.
I'm praying for 2 weeks, my lord.
We are granting 6 weeks.
No, no, 6 is not required, 2 weeks required. Because it is urgent also, because due to ensuing
Sir,
election.
we want
taken.
to dispose of the matter. You
No,
are
2 weeks,
seeking
after 2 weeks, my lord, I'm praying for 2 weeks.
So we are granting 6 weeks,
No, I'm praying for 2 weeks, my lord.
3 weeks.
Yes, obliged.
Obliged, my lord.
I have indicated you have not tried to,
What a lord.
I have indicated you didn't try to
Yes,
understand.
I have, but sometimes what happened, you know, last moment, problem may come up, that is why. I'm not saying it is, my lord. I don't like it.
Lordship,
Yes,
I'd like to pray for some time, Lordship.
what is the matter?
Lordship, this is with regard to allotment of a land to the petitioner number 2, Lordship.
Eviction.
Yes, Lordship. Yes, Lordship.
What do you want now?
Lordship, kindly grant me some time to file my rejoinder, Lordship.
What reason that?
Lordship,
Have you been allotted?
Lordship, it was in the process, the finances were sanctioned for it. And they've also filed an affidavit, circle officer, saying that they will go for the allotment if the High Court permits. However, Lordship,
What is the permission of the High Court is required, sir?
Lordship, however, there is a
I think
difficulty
not,
that
It talks about some PIL, some direction in the PIL. That has not been specifically mentioned here.
So, sir, you bring that PL, since PL covers the land and as such.
PL number 10 of
will be done as per
2018.
the procedure if the Honorary High Court permits. Where is that order?
The PIL number is mentioned here.
Yes,
The PIL
you should have annexed it, we don't know. Do you have any idea?
Lordship will have to go through it.
You bring this judgment or
18,
orders of the
PL.
in PL. Allotment settlement proposal be done as per the due procedure if the High Court, Honorable High Court permits. Your affidavit is not defending your action.
It is not very happily drafted.
Yes,
I'll take the,
rather
Orders-
it's supporting the case of the petitioner.
it was allotted to them, that's correct, but there may be some direction in the PIL as it appears from this.
No, MS
And Begum.
learned counsel for the petitioner. Praise for it is granted 2 weeks time to file affidavit in reply. Next para. Having perused the affidavit in opposition filed on behalf of
On behalf of the Deputy Commissioner, Circle Officer has filed them.
Circle officer.
Come Metro.
on behalf of respondent number 5. Who is respondent number 5?
Is a circle.
Circle officer.
Why circle officer? It's an allotment of the land, government should file. I mean. Wherein a statement has been made that since the PIL number 10 of 2018 covers the case of the petitioner in respect of the land in question. allotment public settlement proposal shall be done as per due procedure. If the Honorable High Court permits. The next part. Having considered above, learned additional
Senior government.
senior government advocate, Mr. B. Talukdar,
BJ.
BJ Talukdar, to place on record, place the judgment public order in the PL number 10 of 2018 on the next date of listing.
Lordship, interim may be extended.
We'll vacate it. Interim order passed earlier shall continue.
Much obliged.
Your lordship. My lord, here in this case, lordship, the petitioner is the farm lordship who engaged in construction workship was allotted a work lordship for construction of classroom in the Rongia College lordship. Page 16 is the work order lordship, which was issued by the principal lordship of Rongia College. For construction of works, estimated amount was 86,49,000. Page 16 is the work order lordship. On 31/5/2017, work order was issued lordship to me, and accordingly on next page lordship, page 17 lordship, the contract agreement was made executed lordship between the petitioner and the principal of the Rongia College lordship. Wherein lordship, it was directed that the work shall be completed on or before 31/1/2018. So thereafter lordship, petitioner had completed the work lordship much prior to that time. And accordingly, the principal also issued an work completion certificate lordship, page 18 lordship. Page 18 is the work completion certificate, wherein lordship, it was stated that work completed on 25/12/2017.
Yes.
Yes, lordship. So page 18 is the work completion certificate lordship, which was issued by the principal lordship, that work was completed on 25/12/2017. That is much prior to the lordship cutoff date lordship. And thereafter lordship, the bill was, there is at serial number 6 lordship, up to date bill value was 70 lakhs and final bill value under process. So 86 lakhs out of 86,49,000 lordship, 70 lakhs was paid and final bill was under process. Thereafter lordship, petitioner ran from
Bill value. How much?
that 70 lakhs was paid lordship. So 16,49,000 unpaid. You mean?
Yes, where it is.
So that lordship, that serial number 5 lordship, CA value, that is contract agreement value, was 86,49,000.
Yes, it is the value, but then up to date bill value is rupees 70.
Yes, lordship, and final bill under process. So 16,40,000, because total lordship contract was 86,49,000.
Yes.
And that was also completed. And on that date, lordship, as per on 5/3/2018, the 70 lakhs was paid, lordship. And remaining final bill, remaining amount under process, lordship.
I think you are.
Thereafter, lordship, petitioner ran from pillar to post for that remaining amount, lordship. And finally, lordship, he preferred a read petition before this honorable court, lordship. 7020/2021.
You have
Page
withdrawn
20.
that.
Sorry, lordship.
You have withdrawn that.
No, that was after filing of that read petition, lordship. The principal wrote a letter to me, lordship, page 20, lordship, 24/3/2022, that 4 lakhs was paid to me and assured that the remaining amount would be paid to me in installments.
Where it is.
Page 20 is the letter, lordship, which was issued by the principal, wherein it was stated that with reference to the subject cited above, the college authority has discussed on the matter of payment regarding construction of part of connected Rusha building under the head of college development. In this connection, the college authority and members of the construction committee has decided to pay rupees 4 lakhs only to you, and the remaining amount will be paid in installment basis as per your estimated cost after receiving the fund from the higher education department, Government of Assam. You are asked to withdraw your case against the college authority and take your aforesaid amount at an early date.
Yes.
So, Lordship, I have withdrawn that order, Lordship, page 22, Lordship, on 26/4/2022. Page 22, Lordship, order that I have withdrawn on receipt of that 4 lakhs. It is submitted that the second para, Lordship. It is submitted on behalf of the petitioner that the authority of Rongya College issued a letter under reference dated so and so to him, informing that he shall be paid rupees 4 lakhs in respect of construction of part of the connected Rusa
Okay,
building.
then what
So
happened?
thereafter, Lordship,
4 lakhs paid,
4 lakhs paid, Lordship.
then
So remaining 12,49,000, that was not paid yet, Lordship.
how do
So-
you know?
Thereafter, Lordship, I have preferred this writ petition. Also, I have issued a demand notice. Page 24 is the demand notice, Lordship, for payment of that 12,49,000 to me, but that was not paid, Lordship. Thereafter, I preferred this writ petition. And after filing of this writ petition, Lordship, now the principal of the Lordship Rongya College filed the affidavit in opposition, Lordship, wherein he stated some contradictory statement, Lordship. He stated that, Lordship, that work order which was initially issued to me amounting to rupees 86,49,000 was subsequently, Lordship, modified in 2 work order. One is for 70 lakhs and
It's
another is for,
It was on an internal arrangement.
sorry, Lordship.
Was it pursuant to any advertisement, NIT?
That was pursuant to NIT perhaps, Lordship, but work order was
Perhaps-
issued.
or
Your Lordship,
perhaps you come to page this instruction. After the page 25.
page 25.
You have the instruction, this copy,
Lordship, I have no instruction, Lordship.
the copy of this instruction. That's what they are saying now.
They have filed affidavit, Lordship.
What
Your
they are
Lordship,
saying now?
kindly see the affidavit.
Hmm.
They are now saying that in one paragraph, Lordship, they are saying that there are 2 work order, Lordship. That was modified subsequently. But till, Lordship, earlier writ petition, Lordship, there are no such statement on their part, Lordship. Now they are stating that there are 2 work order. One is 70 lakhs and another is 16,49,000.
Hmm.
And I have completed regarding 70 lakhs
So
work order.
now you, by your own saying, it's become clearly a disputed question of facts. And at the same time, the work was not been awarded pursuant to any NIT.
The
So-
work order was issued, Lordship, to me.
Work order issuance is something different. I mean, this is one thing, but it has to be preceded by NIT.
Lordship,
And there's the communication from the Director Higher Education that it was purely on internal arrangement, which shows that there was no NIT.
Lordship,
So now you
work
yourself
order is
said
at
that
page 16, Lordship.
their stand is that they have issued work order for 70 lakhs and 60 lakhs, something like that. It become a disputed question of facts.
No, that
You approach the civil court.
Lordship, Lordship,
They are disputing now.
no, they are not disputing, Lordship. Even they have stated that they are ready to pay.
Till
Lordship.
earlier application,
No.
writ petition,
No, Lordship,
they said that 4 lakhs immediately the principal will pay, thereafter
my lord,
rest of the amount shall be.
my lord, your Lordship may kindly come to
Process.
their affidavit, Lordship,
Yes.
wherein they have admitted, Lordship, that they will pay it.
Where it
But-
is.
Your Lordship may kindly come to their affidavit,
Who
Lordship.
is respondent number 4?
Lordship, they have already filed their affidavit, Lordship. This is
Yeah,
the
where it is?
affidavit at page 31, Lordship, paragraph 7, Lordship.
Ah,
That with regard to the statements made in paragraph so and so in the writ petition under reply, your department denies the same and states that
paragraph 7.
paragraph 7 of affidavit in opposition, Lordship, filed by the principal, Lordship.
Page 31, yes.
Yes, Lordship, that under reply, your deponent denies the same and states that the petitioner had tried to malign the reputation of Rongya College on several occasions by adopting different means. In one such incident, the petitioner approached this honorable court by way of filing writ petition, that earlier writ petition, and your deponent, upon considering the greater interest of Rongya College, immediately took up the matter and other authorities of the college, wherein it was decided to propose that the amount of rupees 16,49,000 would be paid to the petitioner in installment, and the appropriate steps were taken accordingly. Thereafter, in next paragraph, Lordship, they have stated, writ petition under reply, the deponent denies the same and states that the petitioner had approached the deponent with malified intention to forcefully grab money from Rongya College without first completing the works entrusted to it. Your deponent had some financial constraint with regard to payment of the whole amount at a time, inasmuch as the main source of income for the college is admission fees. However, under various schemes of the government, students were able to get free admission. Subsequently, the fee is reimbursed by the government to Rongya College. The said process takes time, and amounts are not received immediately. As such, the amount was proposed to be paid in installments. Your deponent would receive certain amounts of money only upon fresh admission of students, and the same would happen only yearly. The petitioner was told to wait for the next session verbally for next installment, but instead he preferred the instant writ petition. After filing the instant writ petition, the petitioner never approached your deponent. The issue with regard to completion of works amounting to rupees 16,49,000 and remaining payment of rupees 12,49,000 could not be made in his favor in terms of the letter dated. Your deponent kept a check.
Yes. You are ready to pay. Check is ready.
Lordship,
Page 32.
it was ready, but Lordship, that aspect.
If it is ready, why?
Since there was an undertaking before this court, Lordship, we thought that we'd have to pay it.
No, we're not concerned now. Your affidavit, you are
otherwise the
saying in
work-
terms of the letter dated, your deponent kept a check ready for the pay, the next installment in favor of petitioner, but the petitioner did not approach the deponent after filing this.
Since he-
You approach.
Since he needed to complete the work, Lordship, he did not.
No, we're not concerned now. You have said you have kept the check ready just because he has not approached. Instead, he has filed a writ petition. You cannot deny. Pay. Not by the government, by the principal. You have kept the check ready. You just release it.
Lordship,
That's all.
that was done in order to save the interest.
Sir,
of
you
the-
read page 32,
Lordship will also consider. the-
last line, last four lines.
I know that, Lordship. I know.
Then
Lordship will also consider the.
what consider now? On what you have said,
Maybe,
the
Lordship.
check is ready.
Yes,
then-
Lordship. Since Lordship will kindly turn to page 22 once, Lordship.
What is there?
This is the order of this honorable court on the last occasion.
Yes. What is there?
Lordship.
What
when
is
this
said? You read that.
Lordship, I wanted to show that when this case was withdrawn by the petitioner, Lordship,
Yes.
the principal did not appear before this honorable court, Lordship, and it was withdrawn on his own instance, Lordship. And no such undertaking was given at that point of time, Lordship, before this honorable court. It
My
was
lord-
on his own instance, basing upon the letter issued by me. And in this affidavit, I have stated, Lordship, that this letter was issued only to save the interest of the college from being maligned, Lordship.
You read.
Lordship, page 22, order dated 26/4/2022. Heard MS NJ Begum, learned counsel for the petitioner, and MS A Gayan, learned central government.
Second para.
Lordship, the respondent number 4 did not appear. That's what I wanted to show, Lordship.
Why is the question appearing? Your lawyer has appeared.
No, not appeared, Lordship.
You read.
It is submitted on behalf of the petitioner that the authority of Rongya College issued a letter under reference number so and so dated 24/3/2022 to him informing that he shall be paid rupees 4 lakh in respect of construction of a part of the concert Rusa building in the said college, and the remaining amount shall be paid to him in installment basis
as per his estimated cost after receipt of fund from the Higher Education Department of the state. This was submitted by the petitioner lordship, and basing upon that,
That letter, page 20.
maybe lordship, but the principal did not appear before this court lordship.
Not necessary. Based on the letter by the principal.
Now,
Are
lordship,
you disowning this letter? Are you disowning this letter?
Not disowning.
no, lordship.
Then
Then lordship, I wanted to say that lordship, some works are yet to be completed and no
why not
work completion order has been issued.
why
in
you
the
have kept the why you have kept the check ready for payment when it was not completed?
Lordship, it was to be paid in installment, lordship. It was to be paid in installment as per
4 lakhs you have already paid, right?
lordship.
Remaining 12 lakhs you are not disputing.
No, we are
Except saying,
disputing to the extent that he has to complete the work, lordship. He has to complete the work.
then why you had to keep the check ready? Page 32.
If he approaches lordship, then we ask him to complete the works, lordship, because there were several resolutions adopted by the school management, college management committee, lordship, to
Where your statement? You
with regard to the non-completion of that work, lordship. Page 30, paragraph 6, we have clearly stated, lordship, that there were several resolutions adopted to ask the petitioner to complete the works, lordship.
My lord, that completion certificate was already issued in the year 2018, lordship.
where it is?
Because no instance, lordship,
Where it is? Where the completion?
that completion certificate, which I have already shown your lordship,
Page
at
20.
page 18, lordship. That is the letter issued by the principal, lordship, that work completed on 25/12/2017. Name of the work was also there, lordship. The work order along with date. That work order is, lordship, regarding that 31/5/2017 work order. That page 17 work order, regarding that page 17 work order, lordship, they have issued this completion certificate to me. So now, lordship, no question regarding completion of any further works, lord.
Yes.
Even on what they have admitted that they have already issued a check.
Page 18.
Yes, lord.
Lordship, the fact that the work order was modified is not denied by the petitioner, lordship.
But you have said here, work completed on 25/12/2017.
That was with regard to the work which
Construction
wherein
of
the
classroom.
estimate was of lordship 70 lakhs, lordship.
Huh?
That was the work wherein the estimate was of 70 lakhs, lordship.
86. What about this contract
What-
agreement value?
My-
86 lakhs 49.
Lordship, subsequently, this work order, which is at page Lordship 16, was modified, and that modification, Lordship, will find at page 35, Lordship, 35 and 36. So there were two work orders, Lordship. 35 and 36, Lordship.
70 lakhs.
Yes, Lordship.
Classroom include technology enabled classroom. Classroom at first floor of digital classroom building, Rangia.
Then, Lordship, with regard to page 35, Lordship, that amount was to be paid to him, and it was paid, Lordship. And with regard to that, Lordship, this completion certificate is
Construction
at page
classroom
18,
first
Lordship.
floor of digital classroom building. Work order so and so 6.3105. So according to you, this 70 lakhs has already been paid,
Lordship.
and this page 36 is a modified or subsequent work order
Lordship.
for an amount of rupees 16 lakhs 49,000,
Yes, Lordship.
right?
Lordship.
Although the initial contract value was of 86 lakhs,
Yes, Lordship.
is it so?
Yes, Lordship.
So 70 lakhs has already been paid
An additional 4 lakhs has also to be paid, Lordship.
out of 16.
Yes, Lordship.
16 is a subsequent work order.
Yes,
Lo-
yes.
Lordship, initially what was happened, Lordship, in the work completion certificate, page 18, Lordship, that serial number 2, Lordship, that was mentioned work order number and date. That work order number and date is regarding, it is not a fact that, Lordship, the principal being holding a public post, Lordship, he is not aware about all such letters, all such dates, Lordship. That work order number and date, Lordship, mentioned as RC stroke 21 stroke DV 2017-654 dated
Yes,
31/5/2017.
86 point
That is regarding, Lordship, page
49.
16.
minus 70 comes how much? 1649.
Lordship.
Then it's the
Lordship.
same work order. You have just modified the terms,
Yes, Lordship.
has modified and remaining amount of rupees so and so, so and so. Only you have modified, issued this letter by modifying certain things
Now,
on the remaining amount of 16 lakhs 49,000.
Lordship. Lordship, we have said that we are ready to pay, Lordship, but the thing is that he has not completed the work work with regard to that 16 lakhs 49,000, Lordship.
You have said completed in
No,
2017.
Lordship, in the affidavit, we have stated that it has not been completed, Lordship. And with regard to that, Lordship,
You have issued a completion certificate. You have issued a letter that he's entitled for these. amount.
Lordship will kindly turn to page
And then by
43
filing
once.
a subsequent
Lordship will kindly
affidavit,
turn
how
to
can
page
you change?
43 once, 43.
The analogy of Mahinder Singh Gill will apply.
Lordship will kindly turn to page 43 once, Lordship. 43, page 43 once.
Yes. Okay,
43.
yes.
Lordship, this is a letter with regard to which, Lordship, we stated that he should need to complete the works, Lordship, at the earliest. I am reading it, Lordship. I am directed to inform you that after several verbal information given to you regarding defective construction of new classroom building under RUSA grants, along with electrification, toilets, etc., you are again reminding to repair the defective construction, etc., within 5 days after receiving this letter, failing which the college authority will take appropriate action on you as per work orders agreement and civil works rule. This was their, Lordship, and subsequently, page 44, Lordship. He did not act, Lordship. And subsequently at page 44, resolution number 11, right at the bottom, last paragraph, Lordship, of that page. This is a resolution of the governing body, Lordship. GB observes the construction of building by MK Enterprise, and it is resolved to direct the MK Enterprise to repair all the damaged walls. After verification and testing of the work by the competent authority, the final project report may be made. This was a resolution undertaken by the governing body, Lordship. It was of 23/7/2018, and subsequently another resolution is there at page 47.
No, you have not said that he has not completed. You said they have to repair all the damaged walls.
Lordship, it was a part of the work, Lordship. It was a part of that work, Lordship.
No, once you have issued a completion certificate, that work
Lordship,
has been completed.
I have
And
stated in the
thereafter, if
affidavit
certain
clearly,
damages are there, it should be as per your terms of your agreement.
I have clearly stated in the affidavit, Lordship.
Affidavit will not. It
How would I
your,
prove, Lordship?
your own
How would I prove
own
that?
admission that he has completed the work.
No, Lordship, I have not never stated amount, Lordship, that he has taken.
Whatever page 18,
Lordship, this is the work order with regard to the work of 70 lakhs, Lordship. I'm stating again and again, Lordship.
no,
There
sorry,
were two work
sorry.
orders, Lordship.
sorry. It is a contract value is 86 lakhs 49,000.
Yes, Lordship.
You have paid out of that, the up to date bill value, up to date 70 lakhs that you have paid. 86 minus 86.49 minus 70, how much it comes? 16.
16 lakh 49.
So remaining, you want to have some modification in the work. All right,
That-
out of the same contract.
Yes.
Then according to him, he has already completed, the certificate has been issued in 25/12/2017.
This certificate was issued after the modification was done, Lordship. This certificate was issued after the modification of that order into two was done, Lordship. That's 70 lakhs and 16 lakhs 49,000. Two order were issued, Lordship. That order of modification was issued prior to the completion of this completion certificate, Lordship.
If it is prior to the completion of certificate, how can you have this issued the certificate, the completion certificate?
Lordship, I don't know what was wrong, but then Lordship, this amount was clearly mentioned in this completion certificate, Lordship.
Up to date bill value,
Lordship. That much only.
then why you have said work completed on 25/12/2017?
I have clarified in the affidavit subsequently with regard to this, Lordship.
Yes.
And Lordship,
My lord, in page 18, lordship, regarding that completion certificate, lordship, if as per my friend's submission, lordship, if that lordship work order was modified prior to that lordship issuing of that work completion certificate, lordship. So in serial number 2, lordship, the work order which was mentioned, lordship, that is regarding that lordship 31/5/2017 work order, which is amounting to rupees 86 lakhs 49,000. So there are no whisper, lordship, about the modification of work order or
No.
anything.
What about this page 43, 42 and 43?
Lordship, that was lordship modified. They have modified it subsequently, lordship. They have that repairing, lordship. They have issued it for repairing. So after lordship on the work completion date, lordship, after lordship inspection of the building, lordship, they have issued that work order completion certificate, lordship. So subsequently repairing work, lordship, how I can done? Because anything may happen, lordship, after completion of a building, lordship, due to natural calamities or anything.
So you go to the principal,
Yes, lordship, I will approach, lordship.
you go to the principal, withdraw the dispute, otherwise you are dismissing. It's become a disputed question of facts. They are not clearly admitting.
Lordship, they on oath, lordship, they have admitted that their check is ready, lordship, for payment. So why they, what they obstruct me, lord?
We'll
Them,
give you a
lordship.
liberty to approach him, approach the principal.
So again, they will not, because if,
That matter instead, you have the other remedy,
my
appropriate remedy.
my lord, your lordship may kindly adjourn the
File a
matter
manish- No,
for 1
no,
month,
no, we
lordship,
have heard, no, no.
so that I can
No,
approach
no.
them.
Are you? Would you like to, would you like to approach the principal or will dismiss on merit? Will dispose?
So I will approach the principal, lordship, as per their oath affidavit, lordship. On
Hmm.
oath, they have stated that they will issue, they already check issue, lordship, issued.
If you want to approach, you
So
go,
I will approach, lordship.
that's all.
So
We'll
that's
close
why
it.
liberty may be granted to approach them, lordship, and as per their lordship statement in on oath, lordship, they will lordship release the same, lordship, within certain time
Will
limits.
not say anything. We'll say you will be given a liberty to approach the principal. Whatever you want to do it, do it.
Lordship, lordship,
But
otherwise, lordship,
Mr. I,
NH Borbuya,
huh?
NH Borbuya.
NS Borbuya, land counsel for the petitioner, and also heard Mr.
I am MP Sharma, Lordship.
all of them. MP Sharma, so and so. Mr. Borbuya, land counsel for the petitioner. after arguing the matter at some length, submits that he may be allowed to withdraw this writ petition with a liberty to approach the respondent number,
4, Lordship.
respondent number 4, i.e. the principal Rangia College, for raising his grievances for payment of the balance amount of rupees 12,49,000 on account of the work executed work of what? What construction? Work of construction of classrooms
Lordship.
at first floor of digital classroom building of the college. Mr. Having considered the submissions of learned counsel for the parties and also on the perusal of the affidavit filed by the respondent number 4, the principal of the Rangia College, this court finds that the claim of the petitioner for payment of rupees balance amount of rupees 12,49,000 for construction of classrooms initially out of estimate amount of rupees 86,49,000 appears to be disputed. Disputed, comma, and as agreed to by the learned counsel for the
My lord,
parties, the writ petition
My lord, that
states
observation, my
as
lord, as they
withdrawn
have
with a
stated,
liberty to approach the liberty to the petition, liberty granted to the petitioners to approach the principal Rangia College in view of the fact that the principal is ready to pay the balance, said balance amount, provided the petitioner completes the works.
my lord, they have stated that check was ready, lordship. So that observation may stand.
You complete and get the payment.
On what lordship they have stated, lord? Otherwise, lordship, again, they will,
You are also not clear. There's a cloud on your submissions also.
my lord, I have a clear submission
You are not. Sorry. Thank you.
of like,
You approach, work it out,
lordship.
get the payment. Ah. No, clear this first.
Please, your lordship. Conducting counsel for the matter, MI is not present due to some medical issues.
So,
Kindly take the matter after 2 weeks.
yes,
Lordship, in this case, your lordship, I am entering appearance, your lordship, for the private respondent number, private respondent, your lordship. And your lordship, I have seen your lordship, our affidavit has not been filed yet, your lordship. Your lordship may take it up after 2 weeks. In the meanwhile, we will file an affidavit. We want to bring one particular order before this honorable court.
Yes.
Earlier, they have filed a writ petition, your lordship, which was withdrawn, your lordship. That's new. That we, Second round of, in the earlier petition, they have withdrawn it to seeking liberty to file a civil, to go before the civil court.
Where it is?
That is your lordship, that order.
Affidavit filed by?
The respondent number 8, Your Lordship. It is that running page number 73, 72 it starts.
Okay.
At page 74, Your Lordship, you find the obligation.
Approach the civil court. Yes.
Lord.
I don't have the brief, my lordship, I don't have the brief.
When is coming?
He's not present due to some.
When he can be present? When it,
Lordship, he asks, instructed me to, ask for 2 weeks times.
1 week. We'll take it up to 1 week. You apprise him. We'll just record it. Mr. So-and-so, learned counsel for the learned counsel appearing on behalf of Mr. M.A.I. Hussain. Press for adjournment of the matter, stating that Mr. Hussain is indisposed today. Mr. MS R.S. Chaudhary, learned counsel for respondent number 8
8, Your Lordship, yes.
I am for 9 and 10. Your lordship.
and Mr.
Yes, board of the-
S. Bortaka, learned counsel for respondent number 9 and 10. Referring to the affidavit filed on behalf of respondent number 8, submits that the writ petition has, writ petitions have filed the approached this court earlier, being WPC 5257 of 2022, and subsequently withdrawn this same with a liberty to approach the civil court. This has not been mentioned in the writ petition.
It did.
However,
Mention করিস। খালি civil গাঁথি দিয়া না।
no statement has been,
Statement is there, your lordship, in the writ petition, but the cause for withdrawal, your lordship, that has not been mentioned. Only a statement that they have
Without-
prepared a
without-
writ petition. But I find it-
mentioning the cause of withdrawal of the earlier writ petition, which amounts to separation of material facts. Having considered the learned counsel, Mr.
MK Alon.
is directed to apprise Mr. M.A. Hussain, learned counsel of the petitioner, which appears, although to be within his knowledge, Mr. list the matter after a week.
Lordship,
For
can we
final-
fix it on 7th of?
7th is what?
Wednesday, Your Lordship, next Wednesday.
On 7th.
Did
You
we-
apprise him.
Obliged.
I have recorded, you take the order today by evening, if you have any confusion.
In pursuance to the last order, the lordship kindly see the order date 28/3/2025.
Yes,
Lordship, instruction received, lordship.
My lord, as per the order, my lord, they have to file affidavit.
Lordship, but lordship, instruction received, lordship, and in that instruction, lordship, in the order dated 24/07/2023 was issued by the then Director of Municipal Administration Assam, perhaps on the humanitarian ground only, lordship.
yes, that matter.
Lordship.
my submission stands, I think my learned friend will actually substantiate my argument, what I have actually placed before your lordship on earlier occasion. Otherwise, I prepared a.
He
set
is,
of
appears
written-
to
file an
ap-
affidavit, I will
appear-
give reply, ma'am.
appears to have been,
No, let them file a reply,
no,
affidavit,
sir,
I
I'm
give reply.
just, no, that will say, but then by this instruction, it appears that the learned lawyers has nicely briefed to the authority.
My lord. My lord, I'll give reply, my lord. Everything, my lord, your lordship kindly put it
I
on
would say
record.
appropriately briefed to the authority. Same stand, he's correct. His stand is being fortified by the government. You place on record so that.
By affidavit, my lord,
Alright, I will look.
Heard Mr. T.J. Mohammed, Learned Senior Counsel, assisted by M.S. P. Bhattacharya, Learned Counsel for the Petitioner. As directed by this court. No, on 28/03/2025. Mr. J.K. Goswami, Learned Additional Senior Government was granted further time to receive instruction for filing affidavit as directed earlier on 24/03/2025. Today, Mr. Goswami, running additional senior government advocate, by placing the instruction that it, copy of the instruction dated 19, placing the copy of the, placing the communication dated 19/04/2025. I submit that he may be granted further 2 weeks time to bring on record the said communication. Will not comment on it now.
Lordship,
Should I?
Lordship,
Should I record my view here?
maybe recorded.
You take it back. It's okay.
Lordship.
Your lordship, I appear for 456.
Mr.
D. Bora.
This is 2 weeks time, right? 2 weeks time to file, to bring on record the said communication. Mr.
D. Bora.
D. Bora, Learned
37 as well.
Standing Counsel,
No,
Learned Counsel for the
Hey,
4,
4, 5,
4 and
6.
5, 4, 5 and 6 is present. You don't have anything to
No. Let
bring
them
on
file the
record.
affidavit.
You have already filed.
Yeah, I have. filed.
Yes, yes.
Yes, file, I will file, reply also.
List the matter after 2 weeks.
Deep love. petitionটা আমার আছে না? আমি কি আছি? My lord, in this case, my lord, I am appearing on behalf of the respondent number 3, 4 and 5.
Yes.
My lord, I want, my lord, 3 weeks time to file affidavit, my lord.
Okay. Heard Mr.
Education.
Learned Counsel for the petitioner. Petitioners or petitioner?
Petitioners.
Petitioners. What is the matter?
Matter, my lord, regarding, my lord, they are enforcing the municipal land.
Okay,
And my lord, their eviction notice was issued and they have challenged it, my lord.
as prayed for by Learned Counsel, Learned Senior Counsel,
On behalf of
appearing on behalf of
Chief Secretary Municipal Board, my lord.
respondent number
3, 4 and 5.
3, 4 and 5. Come on. Let this matter be listed after 3 weeks so as to enable the respondent number 3, 4 and 5 to file affidavit.
Deep love.
My lord, kindly peruse order dated 19/6/23.
Yes. 24/7,
My lord,
24/7, 2024. You have sought for a time
my lord.
to apprise this court as to whether judgment in Monisha Khatun Monisha Khatun is applicable or in this case.
My lord, Monisha Khatun, my case is that, my lord, I have filed prior to that judgment.
Doesn't make a difference.
The judgment petition I have filed in the year 2023.
Yes,
Judgment come in 2024.
so it's pending.
Here, my lord, held that the
Where is
Yeah,
this,
okay.
Monisha, will appear with the respondent? What is the matter, sir? What do you want?
My lord, regarding some ex-gratia payment, my lord, in terms of
Within nature of
notification.
the should not be issued directing the respondent to pay the excess of 2 lakhs that will against the is disease and non-living and who died and Indian. Yes, where is that judgment?
Prior to that, my lord, my friend has some, my learned friend.
I have received some instruction that amount was sanctioned way back in 2023.
Yes,
My
amount of 2 lakhs has been accorded to the NOP of deceased late pension and communicated the revenue and sanction for an amount has been accorded to NOK.
Must have been given to him.
So,
my lord, then
Next page is
time
the
may be given,
sanction.
okay.
whether it is released or not, my lord, I.
No.
That information.
In pursuant so on the basis of police report a sanction is accorded for an amount of issued on
Sanction only, yes.
who died due to
22.
payment of execution subject to receive fund from the government. Once it is sanctioned,
My lord, once sanctioned, my lord, it has to be released, my lord, whether it is released or not.
that
my
it's your job to find out.
Yes, sir.
So, my lord, sometime.
What
it
is your statement that this is a 14/7? Right? This is a 14/7.
Sanction order, my. Yes.
You have filed this writ petition on when?
I filed this petition, my lord,
This
16th of February.
16th February 23. 16th
Yes,
February.
after that only. Before the sanction you have filed.
Yes, my lord. But,
We're closing it.
but,
Heard, Mr. So and so, learned counsel. This was,
fair, my
this
lord.
order, this
Whether it was
communication was placed earlier also,
Which one?
before this court, this same 15/7,
No,
right?
because that was passed way back in 23, sir.
Yes. This communication is of 15/7. It's here. It's already here.
My lord will say one thing, my lord, that if not released, the same may be released, my lord. Only that much, my lord.
No, you could have.
My lord, sometime what happens, sanction is made, but release is, may not be released, my lord. So only that much, my lord. If not released, the same may be released. Only that.
Thank you. Move it up. Next one.
Next case.
Next. sir. What's up?
Heard me, sir?
M.R. Khandakar.
Huh?
M.R. Khandakar.
Amar Khandakar, Learned Counsel for the Petition, and Mr. B.J. Talukdar, Learned Additional Senior Government Advocate, for respondent number. No, in that case, first, right, G has the, MSG has the Learned Counsel for, oh, sorry, N. Bordolo, for respondent number one.
Yes, sir.
Standing counsel for respondent number one. Land standing for revenue and register.
I am 3, 4, 5, and 6. 6 and 7.
For respondent number one. Finance. And then this is BJ Talukdar for respondent number. The additional senior government for respondent number. 3, 4, and 5. 3, 4, 5, and 6.
6 and 7.
6, 3, 4, 5, 6, and 7. This application is filed by the petitioner seeking a payment of ex-gratia grant of rupees 2 lakhs to the petitioner against the account of the death of his son, named late Kulchand Ali, who died on 04/12/2018. As per the government notification dated 15/11/2014. Mr. You have filed an affidavit,
We have.
but this was not brought on record. This was earlier to this.
17/6.
You have filed the affidavit before according section.
Yes.
Okay,
At that stage, my lord, the SP's report was not there.
okay. The respondent authorities were filing their affidavit has stated that as per the policy of the state, by notification dated 15/11/2024. The quantum of relief in respect of persons against different categorized incidents, including ex-gratia grant to the next of the kin of person killed due to accident in public places or in public areas within bracket other than killed by extremists, terrorists, miscreants, and due to firing of security forces, bracket close, for a quantum of rupees 2 lakhs. However, the sanctioning of ex-gratia grant to eligible beneficiaries within bracket NOK can be initiated only after fulfillment of criterion as mentioned in the said notification. Mr. Therefore, to ascertain the same, the authorities had not received the police report from superintendent of police. Today, Mr. B.J. Talukdar, learned additional senior comment advocate, by placing the copy of the communication dated 15/07/2023 submits that submits that already a sanction for an amount of rupees 2 lakhs has been accorded to the next of kin of the deceased late Kulchand Ali and communicated to the Revenue and Disaster Management Department on 14/07/2023. Next paragraph. Having considered that the authorities have already accorded sanction for an amount of rupees 2 lakhs to the next of the kin of deceased late Kulchand Ali, who is the deceased, who was the deceased, who is the deceased son of the petitioner, and has agreed to allow counsel to the parties. The before that, not again. To deceased son of the petitioner, who has been how he died?
Already in a road accident.
Who died in a road accident, in terms of the policy of the state, I am not considered good. No live issue remains to be adjudicated. Accordingly, as agreed to the council to the parties, this writ petition stands closed. It is observed that if the amount sanction is not disbursed to the petitioner, same shall be disbursed in terms of the policy of the state.
My lord, may I pray within 1 or 2 months, if not 10?
It's been 2023, 2 years back.
My lord, if not.
I am dead.
Lordship, in this case, the private respondent has filed affidavit in opposition,
Yes,
and the respondent from the official authority
has
their
not filed.
cannot file. So their
Yes.
affidavit will be required, Lordship.
What is the matter?
Matter is that the Assam Board of Revenue has decided title and the legal status of the legal head of the private respondent, which is decided without jurisdiction.
Only, my lord, a dispute between the petitioner and my lord respondent number 5.
Hmm.
A plot of land with a total land, my lord, 12 bigha, 14 lassa, and 4 kata 14 lassa, my lord.
Hmm.
That land was equally divided among the legal heirs, sons and daughters. And each daughter, 4 daughters, got, my lord, 1 biga, 7.8 lassa, admitted fact, my lord.
Hmm.
My lord, my mother, my lord, Fatima Begum, my lord, she, my lord, her name was mutated accordingly.
Hmm.
Subsequently, my lord, the petitioner, my lord, he is a son of one of the legal heirs, my lord, Sirasuddin, my lord. His name has been mutated fraudulently. I made an objection. My lord, filed a petition before the settlement officer. Settlement officer, my lord, my mutation, mother's mutation, my lord, sustained, my lord. Subsequently, my lord, what happened? They came to the High Court, directly came to the High Court.
Are you a petitioner?
I am the petitioner.
So,
My lord, High Court, my lord, this is a second round petition, my lord. Same
Yes.
issue, with the same issue, they have come.
This is this is not the correct submission.
My lord, your lordship, kindly see their petition.
Trying to misguide the court lordship.
No,
Because when he filed lordship, the issue is that the land was mutated in my name in 1996. And after 28 years of the gap,
no, my-
someone who is claiming a biological son of the Fatima Begum, she is my paternal aunt. She claiming to be a biological son and legal heir filed an application before the settlement officer to mutate his name. And it was decided
where's
expertly.
the impugn order?
my lord,
Impugn order of the Board of Revenue.
page, my lord, 50,
Settlement officer.
Yeah, lordship is
57, my lord. 11%, your lordship, kindly see long order, my lord, 59,
59.
second paragraph, my lord. Very clear case, my lord.
Hmm. Having gone through.
Having gone through, my lord,
Having gone through,
having gone, may I read, my lord?
The observations go that the learned settlement has given opportunity to both sides of the head. He also explained the issues and because I really observed that the feeling that we failed to produce Yes.
And
yes,
my
lordship,
lord,
lordship, one issue is that what we find is that issue I have raised first, the private respondent is not the legal heir of the Fatima Khatun. On ground that he is not a biological son of the Fatima Khatun.
Yes.
And the title, he is not entitled to claim title. When the that observation made by the Board of Revenue is that he is a legal heir. On what document? NRC, National Register of Citizens, which is itself not at all an NRC of 1951. There are several decisions of the Apex Court as well as this Honorable Court that NRC of 1951 is not at all an admissible document, which cannot be considered as a piece of document on the basis of which no decision can be passed. So how a legal status of the legal heir shall be established? Only on the basis of the legal heir certificate established, given or issued by the competent authority. It is not on the basis of the NRC.
Learned counsel
my
for
lord,
the petition.
little submission, your lordship, kindly.
Ah.
Little submission,
So
2
on
line
that,
submission. my lord.
on that issue, lordship, their affidavit is required whether NRC can be considered as a document to establish the
It is
status of any
submitted by
legal
Mr.
heir.
My lord,
So-and-so. Learn your name, please.
Mannav, my lord,
Learned counsel for the respondent number
5, my lord.
5,
My lord, may one submission, my lord.
that he has already filed his affidavit. Mr. Government, the learned counsel, the state respondents are granted 3 weeks time to file affidavit.
My lord,
We'll see.
only thing, my lord. Since,
Yes.
my lord, only 2 questions, my lord. has
We'll
been-
see, we'll see. Let
My lord, gifted property should be required to be proved before competent court.
Yes.
And
Let them file the
another issue,
affidavit at the
biological
competent
sons or daughter, that also has to be proved by the civil
So
court. Why
according,
they do not
according
go to
to,
the civil
according
court?
to you, it's a disputed question.
My lord,
Facts.
why they do not go to the civil court,
How,
my lord?
how the settlement officer can decide the issue when the settlement officer illegally.
Yes,
Thank you.
They failed, my lord. They
Thank you,
failed before
thank you. We'll
settlement
see
officer.
after 3 weeks.
My lord, after 2 weeks, my lord.
3 weeks.
My date may be fixed, my lord. Otherwise, my lord,
Who is in possession?
I am in the possession.
no, my
It
lord,
is
it is
my
own
residential
property.
house.
It is This joint property, my lord, maybe
It is
he,
the
his
residential
possession.
house, lordship. I am in the
My lord, it's joint
possession.
property, my lord.
I'm in the possession since 1996.
My lord, joint property, maybe, my lord, his possession, my lord, I am the legal heirs, my lord, my name has been
That
corrected.
has to be established, the legal,
Corrected in your
established by the
favor.
civil.
Yes, my lord,
Any order passed earlier?
No, no. Well, status quo was there, lordship. It may be continued.
maybe continued, my lord.
Oh.
My lord, I date
The
to be fixed, my
affidavit
lord.
of the
Interim
status
order
quo.
has already been passed.
Status only,
Status.
status quo, my lord.
The interim order for maintaining the status quo be continued
My lord,
Lordship.
my lord,
till the
if
next date.
next date may be fixed, my lord.
3
Otherwise,
weeks, we'll see. You are happy with the status quo?
Yeah, he has to be happy because he was claiming that he is in the possession. If his argument is correct.
Thank
he
you,
has to
thank
be happy.
you. Next.
my lord, a joint property, my
Lordship.
lord, always, my lord, what happened, my
We'll
lord.
see, sir, we'll see. We have already done.
Obliged.
It is your lordship. Kindly adjourn the matter for today. The
Your
CA is out of
last
station.
occasion- On last occasion, the CGC sought for some time to file the affidavit.
CTC,
Central Government Council, because this is.
CGC,
Yes,
yes, B Deka.
yes.
Lordship, B Nika is out of station, your lordship.
Hmm?
B Nika is out of station.
Hmm,
Learned CGC.
hmm.
Kindly adjourn the matter for today.
3 weeks time was granted.
Hmm.
Further 3 weeks, you inform her, inform him. Not Mr. Ed Hartland, counsel for the petitioners. Mr. B Deka, let me see this. Represented by Ms. M.S. Swanso is granted further 3 weeks time to file affidavit.
Interim
Yes,
order
sir.
passed.
Interim order plus the letter will continue.
Obliged.
Deeply honored.
Lordship, in this case, I have received the affidavit in opposition. I am paying 2 weeks time
On
to
the
file the
prayer of
reply.
Mr. So-and-so, learn counsel for the petitioner, list this matter after 4 weeks. So as to enable him to file affidavit and reply.
Reply.
Yes.
May please your lordship.
Yes, sir.
My lord, in this case, lordship, pleadings completed lordships.
Hmm.
Lordship, rule may please be issued.
What is the matter?
Lordships, I have received the notice, lordship, from the GMDA,
Hmm.
and that I have committed some violation in case of construction. But there is no violation in construction.
How do we
Construction-
know?
Construction, lordships, it
Who
was,
is the impure order?
lordship, impugn order, lordships,
Is there any impure order? Are you challenging
Lordship.
any order?
lordship, that I have challenged, lordship.
Where it is? Page, sir,
Order,
page,
Page
passed by
lordships, 87 lordships.
87.
87 lordships. That is under challenge, lordship. Lordship, this GMDA, they have submitted the affidavit, lordships. Against that, lordships, I have submitted the
There is
reply,
notice
lordships.
under section CM. Yes,
Lordships, lordships, this construction, it was done in 2006, lordships. at that time, the Satyavati Kakoti Lordships, she was the owner of the land lordships. Lordships, she has
Simply
submitted
show us the NOC
the NOC
for
lordships,
construction.
lordships. Lordship pays 19 lordships,
Hmm,
pays 19 annexure 1 lordships.
hmm.
Letter issued by Harapur Gaopansar lordships. This area belongs to 32 Harapur Gaopansayar, not under GMDA lordships. And on 36/2006 lordships, this Gaopansayar president issued the letter to Satyavati Kakoti lordship. Subject issue of no objection certificate under section 21 of the Assam Panchayat Raj Act 1994 and para 57 of the bylaws of the Gao Panchayat for construction of Assam type RCC building and boundary wall within the territorial limit of the GP lordships. Lordships, here it is altogether G+4 lordships. I obtained that time Satyavati Kakoti obtained the permission and she constructed lordship. Thereafter lordship
You have purchased this land from the Mrs. Satyavati.
lordships from her
Kakoti.
and her son lordships.
Yes, sir. Whether it falls under GMD or Panchayat. Panchayat.
GMDA Lordship. Lordship, may kindly see order dated 24/7/2023 passed in this particular instant case, Lordship.
Hmm.
24/7/2023.
24/7.
Yes, 23.
Yes.
Lordship, may please come to paragraph 11.
Hmm.
Paragraph 11. In view of the specific drawing disclosing the setbacks, the court is inclined to observe that it would be open to the petitioner to remove the illegal construction in the setback area within 11/8/2023, which is the next returnable date, failing which it would be open to the GMDA to proceed with the demolition in terms of the notice after recording the setbacks measurements in the presence of witnesses. The GMDA shall also give a notice to the petitioner to remain present at the site for measurement, and if the petitioner remains absent at the appointed date and time, it would be open to the GMDA to take expert measurement of the illegal construction. Accordingly, till 11/8/2023, the GMDA shall not proceed with the demolition of the illegal construction made in the land of the petitioner without the leave of the court, and that there would be no bar to proceed with the proposed action after 11/8/2023, subject to further order of the court. Lordship, we are only, Lordship, because of this subject to further order of the court, not proceeding for demolition, Lordship. Otherwise, all these submissions, Lordship, lost relevance because of this specific order.
In the interim.
Yes, Lord.
In the while his matter was moved.
On that day itself, Lordship.
Yes.
So we have the liberty to proceed.
You proceed.
Yes, Lordship. Only because
As
of this,
today you have not.
because of this last line, Lordship.
No.
Subject.
You proceed, come back, demolish, and come back, we'll pass order.
Lordship,
Just one
Lordship.
observation.
lordships, this, they have lost the complaints against me on the basis.
No, it's okay. You may have grievance, you may be right, but then when this petition was moved, court has passed in specific order that till 11, certain within the period, no demolition, but thereafter liberty to take.
Lordships, after that lordships, measurement was taken and
Yes.
measurement was taken in my presence also. At
Okay.
that time, lordships, I was also present. Now, lordships, this complaint, this matter has come up when a complaint was lost. A complaint was lost.
Heard Mr. So-and-so learned counsel for the petitioner, because it actually your claims are, it is interim order has been passed and you have not, have you challenged this interim order?
No.
Lordship,
No.
I am I am protected by the interim order, lordships, because
Accordingly, till 11/08/2020, GMD shall not proceed with demolition. Till 8/20/23.
lordship, time to time it was extended, lordship, that interim order, lordships. Time to time it is extended,
Where
lordship.
it has been,
Time to time the matter was listed, lordships.
where it has been extended.
Lordship, it was listed on the last occasion. Te- 10/3/2025 and thereafter also, lordship. Lordship, this interim order passed earlier was continued and being continued, lordships. And lordships, this who lost the complaint against me, against the construction, lordships, he was made the party, lordship. This, and he was made the party, he was served with the notice, and he has not appeared before this honorable court, lordships. No affidavit is
No,
filed by him,
This
lordships.
interim order is what? Accordingly, till 11/08/20, the GMD shall not proceed with the demolition in the without leave of the court, and that there would be no bar to proceed with the property after 11, subject to further order of this court.
Lordship,
So
thereafter,
it has been extended.
it is extended, lordship.
It remains the same. So they can proceed.
Lordship,
This
Lord-
interim order has been extended. That 11, after 11/08/2023, they can proceed.
The effect will remain same law. Same effect will remain,
Yeah,
even if it is extended law, but I'm
that's what I'm
specifically
saying.
not
This has
extended.
been extended. This has been extended.
Yes, even if it is accepted that it has been extended,
extended.
even then it will have the same effect.
Yes,
lordship, first of all,
the
lordship,
extension is to your detriment only,
lordship, first
against
of,
you only.
lordship, first of all,
Anyway, if they are not taking action, what can we do?
lordship, my
because
humble
only
prayer,
because of
at
this
this
last-
stage, rule may please be
What
issued,
rule?
and a date may
Why
please
not-
be fixed
why
for
not
hearing,
convince-
lordships.
I'm not convinced. Heard, Mr. So and so.
Just one more line, Lordship. In terms of this court's order, Lordship, we have already done the measurement and he was also present on the date of measurement. Lordship.
Then you
Yes,
proceed.
we can proceed.
Who is stopping you?
Yes, Lord.
And the all along the interim order has already been extended. That is in your favor, extended in your favor,
Yes, Lord.
not his favor.
Yes. Obliged, Lord.
Because interim order clearly says there should not be any bar to proceed with. Of course, that action will be subject to further orders. So they can demolish, no issue.
Lordship,
We'll not say anything now at this stage.
Just one
You
observation.
proceed, you
Lordship.
proceed, what's there?
Yes, Lord. Lordship. Lord.
lordships,
I am of the clear view, the extension is the interim order only, which says after 11/8/2023, there shall not be a bar after the measurement.
Yeah.
To proceed with. Of course, that action will be subject to further order.
Any further order.
So until we pass any order, you may proceed.
lordships, it
Hard
was,
Mr. So and so learned counsel for the petition. Pleadings are complete. List for hearing. After 3 weeks. We'll hear you after
lordships,
3 weeks.
interim passed earlier will continue, lordship.
Will not say anything. Because to be frank, if the interim order, extension of interim order is against you, they'll proceed with the demolition. Because measurements always been given. Unless we pass other orders clarifying that they should not proceed with or modifying that order. Simply extending the interim order will not help you. It remains the same. All right. So better not to extend it. And if I extend, I'll clarify.
After 3 weeks, lord.
Yes.
of hearing.
2 weeks or 3 weeks, up to you.
3 weeks, lordship.
Obliged, Lord.
May it please, your lordship.
Yes.
Lordship, as per the last order dated, the respondents had sought for time for further instructions, Lordship.
No, last for the last order. Okay,
Lordship order dated 3/10/2024.
3.
10/2024.
No, last order is 29/11/2024. None appears.
Lordship, prior to that order, 3/10.
Hmm?
3/10/2024, Lordship.
Yes. None appears on behalf of the president.
Also, we have received instruction
Yes.
that although the land is not within the forest manner, but it is in the eco-sensitive zone. So
You
whether
file
the
an affidavit.
man
File an affidavit.
lost.
Earlier, Lordship, we filed the affidavit.
The additional affidavit being on record.
Yes,
Heard Mr. So-and-so,
we have the
learned counsel for the petitioner. Mr. BJ Talukdar, learned additional government advocate that he has received an instruction.
Eco-sensitive zone আছে যেটিতে
They received an instruction which reflects that
although the land is not within the forest area. but
although
it
the
is-
land is not within the forest area,
It is on about 670 meters away from forest area, and which is the eco-sensitive zone. So we
comma,
have to-
the same is within the eco-sensitive zone.
therefore, we have to discuss with the forest department prior to.
Eco-sensitive zone. Therefore, what discussion?
Forest, whether that can be reclassified as a commercial land or.
Therefore, certain process has to be taken as to whether the land in question can be classified as what
as Commercial.
commercial land. or-
They have applied for.
Consider
reclassify
the
as
submissions, comma. The learned counsel for the petitioner, learned state council is granted for the 3 weeks time to take appropriate steps. To take appropriate steps as bread for, as submitted above, and to bring on record by way of affidavit. We're granted 3 weeks and you do whatever you want to do and bring on record. So that finally can be discussed. This after 3 weeks.
obliged, Lordship.
Yes.
But my account has been freezed by the concerned bank, my lord. And well, my prayer is for a direction, my lord, to the bank, my lord, to release my account amount, my lord. Because the bank cannot freeze, my lord, unless some illegal transactions, my lord, take place or any fraud, wrong information, nothing is committed by the account holder, my lord.
Yes.
Your Lordship, as per order dated 19/3, we have filed an additional affidavit, given the statement of loan accounts, Lordship.
Hmm?
Now, my lord, they have finished, my lord, on the ground that my husband, my lord, took a loan in the year, my lord, 2005. And I was a grantor to that loan, my lord, availed by my husband. But my husband died, my lord, in the year 2013.
Hmm.
Now, this honorable court wanted to know, to see the statement.
Hmm.
They have filed the affidavit, my lord, annexing the statement with effect from 2010, but loan was granted in the year 2005. So 5 to 10, my lord, silent. That is incomplete statement, my lord.
So have you filed reply?
No, I have not filed reply, my lord. And last time they have filed only that.
Mr. So-and-so, learned counsel for the petitioner is granted 3 weeks time to file affidavit in reply.
I
Put
will
the
file
affidavit in the opposition filed by
file by bank, my lord.
bank, huh?
I will file reply, my lord. Now, if they can file that statement with effect from 2005 to 10, that is incomplete. If
It's
they
up
file,
to her. Up to her.
and I will say only that because that is incomplete. Publish, my lord.
Much obliged.
That is your response.
Yes.
Put a fix for instruction from the government manual.
One instruction I have received, that resurvey is complete. And some process is going on for preparation of that revenue map.
So what is to be done?
Let them file on affidavit manual.
Affidavit is not required, that it take time. Matter as because there is a same other matters in the REIT appeal that is pending.
No, you said but the final notification yet to be issued by the government.
And the further some verification has to be required, whether the person who are have the landed property on there, the date have to be verified. This is done for NC that area and others also. That original record was that was missing.
So what you want sometime
Sometime.
to complete the process?
Lordship.
A timeline may be
Heard
given.
Mr. So-and-so, learn counsel for the petition. Next one, Mr. J. Hendy,
Lordship.
learned counsel
For the state road.
for the state by placing the copy of the report dated 29/04/2025. No, placing the communication dated 29/04/2025. Submits that the process for final notification
Lordship.
would take some time, and therefore press for listing of the matter after 4 weeks. Prayer not being objected to and unconsulted by the petitioner, list this matter after 4 weeks.
Picture.
43 lordships, the 43 lordships we have appear the people just sent for vetting. 42.
What is the matter?
Non-execution of the order of RERA.
The Baki they proceeding.
Which year? So, MS so learn counsel for the petitioner. Petitioners. It's been same.
Same matter, two different parties.
Okay.
One is that instruction not been received. It is we already been sent. That communication is made in then. That we are waiting for the instruction. 40 item 43.
43.
42 is complete. That it was sent for vetting.
Okay. Mr. MS so learn counsel for the petition. Mr. J. Henry, learned state counsel submits that. Copy of the affidavit in respect of to the writ petition 5817 of 2023 as sent for vetting and instruction in respect of the location 582023 yet to be received. Therefore, place for listing of the matter after 3 weeks.
Lordship, a date may be fixed.
Mr. Has agreed to by land council, no, prayer not being objected to by land council for this petitioner. List this matter after 4 weeks. 4 weeks.
Lordship.
3 weeks.
Lordship, 3 weeks of fixed
3
date.
weeks. You give that date.
26.
See. Mr. Majumdar and I chose Air Buya. We'll take it up at 2 o'clock.
Lordship.
That
Item 1 to 11.
time being matter.
Lordship.
And 1 to 11 and 12. Ah.
12.
Yes,
In the last occasion, my lord, time was split for my lord. Any instruction received?
yes.
My lord, instruction not received, Lordship. My lord,
What is the
need some-
matter here?
My lord, a partition application was filed, application for the partition, my lord.
My lord, that,
Let them take instruction, my lord.
my lord, the officer, my lord, the official Lordship, my lord, they are busy in the, my lord, the election duties, my lord. They're too much on-site election.
Again, you will say the one nation, one poll.
My lord, it will better, Lordship.
Since the elevation of this court, we are hearing that excuses every 6 months due to election, panchayat, assembly, parliamentary.
We have to wait. No, sir.
Mr. Goswami.
Sharma.
Yes, sir, my lord.
Yes, sir, land council for the petition. On the prayer, the Mr. J. Hendrik, learned council, learned state council is granted for the 3 weeks time to obtain instruction.
Obliged, my lord.
Obliged, Lord.
Yes, anybody? Non appears for the petitioner, non appears for the parties on call. Please put. It is noticed that on 08/01/2025. Non appears, also non appears, non had appeared for the petition. Mr. Considering about. No, in view of the repeated non-appearance divided petition. Therefore, allow counsel for the petitioner. It will instead dismiss the non-privilege. We'll continue.
That subject away. My lord, I am extremely sorry, my lord. In the first type, I have some. My lord. My lord, my lord has already gone through, my lord. This is a matter, my lord, wherein we were appointed admittedly as a honorary Gaumburas, my lord.
By the villagers.
By the villagers, my lord. That aspect I cannot, my lord, deny or cannot, my lord, substantiate.
Now, my lord, the issue is that the main prayer, my lord, which we have praying before my lord, is that the process of regularization had been undertaken by the government. Even in their affidavit also, my lord, the various communication which were made by the government, my lord, for the purpose of regularization, they have not denied that we have not taken that exercise. Now, my lord, what has happened when, on the one hand, basing on our representation, my lord, when the exercise for the regularization was initiated, and on the other hand, my lord, suddenly an advertisement has been floated for the purpose of, my lord, direct recruitment in these categories of posts. Now, my lord, admittedly in the villages or lots where in, my lord, we were appointed by the villagers, my lord, at that relevant period of time, there was no Gaonpura system was existing at that relevant period of time. Therefore, my lord, the government knowing that as this person had been appointed by the villagers, no steps had been initiated directing the authorities to, my lord, removal from the services which were rendered as a Gaonpuras at that relevant period of time. Now, my lord, that's why when the process of regularization had been started, my lord, I am not saying, we are not, my lord, saying that that process should be come up with a positive manner, or they could have reject us also, my lord, that there is no scheme or provision in the law for the purpose of regularization. But no any logical conclusion they have arrived. Now, keeping the process in the mid stage, my lord, they have initiated the another process of direct recruitment, which, my lord, subsequently culminated and finalized into appointments of the sum of the Gaonpuras, my lord. That is admitted. Now, my lord, those appointment is also under challenge into separate writ petitions, my lord. And in one writ petitions, my lord, what they have done, wherein we have put into challenge, my lord, that the lots or the, my lord, area wherein the Gaonpuras were appointed are required to be persons belong from the same lot or area. That norms has been violated. Now, secondly, my lord, a huge scale scam for job is there, my lord. Basing on our representation, my lord, basing on an FIR lodged by the association, my lord, the Chief Minister's vigilance case had been registered. It had been thoroughly investigated, my lord, and charge sheet has also been submitted before the learned, my lord, Special Judge Kamrup Metro at Guwahati, and the case, as per my last instruction, my lord, is that the case is pending for, my lord, trial. At that stage is their rest. Now, my lord, and thereafter, my lord, we have filed another writ petition by annexing that charge sheet that as these persons are not product of a clear and transparent process, rather they are a product of a scam or cash for job, which is in the reflected in the, my lord, charge sheet also said, so they do not have any right to hold the post of such a serious nature of post of Gaonpuras, my lord. Wherein, my lord, the rule has also said that under such circumstances, Gaonpuras can be removed, my lord. So therefore, my lord, my first case is for the purpose of our rights for regularization, my lord. That is the issue, my lord.
So if I correctly remember,
My lord,
I have suggested either you withdraw this writ petition
my lord.
because after the selection process and
Yes,
the
my lord.
appointment, nothing remains.
My lord,
Number one. Number two, if you have challenged those
appointments, my lord.
appointments,
My lord.
that will be a different cause of action. That will
is-
not,
that is
that
correct,
will
my
not
lord.
have
That is
any
correct.
bearing on the closing of this writ petition.
My lord, with all.
I would suggest
My lord,
to withdraw this with a liberty to, we will grant you a liberty to approach afresh, challenging their appointment if advised.
no, my lord, what will happen, my lord, at that, my
Because
lord?
see, this is, prayer is very clear.
My lord.
Come to your prayer.
Yes, my lord. My prayer, my lord, may be pleased to find starts at page, my lord, 37, my lord.
Recognize the appointed petitioners as Gaonpura against the respective lots shown in the list time to time submitted. This cannot be.
My lord.
Respond to conclude the process, and this also cannot be. That is respond to post of Gaonpura, there is division so and so, when the preserve now been. This is also not possible. And finally, this cannot. All prayers cannot.
My lord, my lord,
See, that
My lord, if I now
You,
withdraw,
you have been appointed not in a sanctioned force.
No.
And earlier at that point of time,
my lord,
there is no decision or the policy of the government to create a post.
that is correct, my lord. That is
And
correct.
you have not been even appointed by the
Deputy Commissioner,
deputy commissioner or for that matter by the government,
my lord.
even for temporary or whatever, which we could have direct to consider the case.
My
This is by the village authority before the policy of the
My lord,
state.
my
You
lord,
have the
under,
Gavuras.
yes, my lord, under such circumstances, my lord, my respectful submission before lordship is like that, my lord. My lordship is well aware, my lord, that in the state of Assam, there are various categories of schools which were at the venture stage, my lord. They do not have any role of the government for the purpose of appointment of these categories of teachers. They are purely private. Now, my lord, what has happened? The government has come up with a policy by various institutes, my lord, like the Venture Educational Institution Provincialization of Services Act and other statute. My lordship is well aware, my lord. Under that act, those person has been even made a government employee giving the benefit of revision of pay rules salary, my lord. Now, my lord, as we are a citizen and the state being a welfare state, my lord, now my lord, may kindly appreciate one thing. I know, my lord, I have a very limited scope to argue before my lord for the purpose of regularization, my lord, but my lord may kindly appreciate, my lord, that these persons who has
No
been allowed,
limited, no scope at all.
my lord, I have to oblige and bow down before my lordship's observation. I cannot, my lord, go beyond that. I know my limitations, my lord. I know my limitations, my lord.
What is the additional affidavit?
My lord, the additional affidavit we have bring
You
on
bring
record, my lord.
record that there is
Yes.
subsequent writ petition
No, no.
challenging the appointment order.
No lordship.
No, I am replying it. I am replying it. Please, kindly bear me. My lord, the additional affidavit is for the, my lord, what we have done. We have annexed the FIR as well as the, my lord, charge sheet, basing on which, my lord, that criminal proceeding against the fresh recruit is pending, my lord. That too-
Now
My lord.
that you have not made them a party, you have not challenged the appointment
No, my
procedure.
lord, their appointment is under challenge in another writ petition.
So that will not.
That's
will
why, my
not
lord,
provide
that's
that,
why, my lord, I am
closing of this
praying
writ
that.
petition, disposal of the writ petition shall not have any bearing on that.
No, my lord, what I am praying, my lord, in a situation like if those persons' appointment has been interfered with, my lord. I am not saying that it will going to be interfered. Such a probability is there, my lord.
So if
Now-
if it you may have that prayer in that writ petition.
Yes,
That will
we
be
are praying for
considered.
a certiorari for setting aside the entire
No,
appointment. of
that
those
will be
persons.
considered,
My lord,
whether your case can be considered in the event if their appointment are found to be fraud or whatever.
then
illegal.
my lord may decide this because I have taken instruction, my lord. The petitioner is not very much eager to withdraw the petition. My lord
Yes,
can decide on merit, my
Yes,
lord, and
yes.
can pass an order, my lord.
yes. That's all.
My lord.
So you are not challenging the advertisement.
No, here in this case, my lord.
Yes.
No, in this case, my lord, what we have done, we are basically praying for the purpose of, my lord, regarding the regularization of our services, my lord.
So what you are saying is that instead of while your prayer for grievance for regularization,
My lord.
under process, the advertisement ought
Could not have
to
been,
been
could not
issued.
have been done, my lord. That is the
So
basic-
directly you are not challenging the
No,
advertisement.
my lord, we are not praying for the setting aside the entire advertisement. We are saying that they can go ahead because it is a state-wise or the district-wise, my lord, other lots are also there, my lord. Now, this honorable court, while considering the, my lord, at the motion stage, was pleased to issue notice, and even in the interim, my lord, there was an stay order operating that there should not be any appointment in the lots wherein the petitioners are, my lord, engaging or working as a Gaumvraj. Now, subsequently, my lord, that interim order had been modified pursuant to an application presented by the deputy commissioner that the subject to selection has been made, my lord, that the appointment, if any made, shall be the, my lord, subject to outcome of the present writ petition, my lord.
These are the Gabura, these lots numbers are being advertised, have been advertised.
Yes, my lord.
Where you are
Wherein,
Okay.
my lord, we were appointed by the villagers.
on the strength of village authority.
My lord.
Villagers.
Villagers.
If my lord may be pleased to take up the annexures, my lord, if we go by the annexure, my lord, this is the annexure one at page 40. Is a notification dated 5th of January 2015, my lord. By which, my lord, this is the first time the governor of Assam is pleased to introduce the Gaonbura system in the district of Goalpara, Dhubri, Kachar, Kokrajhar, Karimganj, Hailakandi, Bongaigaon, and Sirang. Now, my lord, when this notification was issued, our area was under the Dhubri district, although later on, my lord, the South Salmara Mankachar has been earmarked as a separate district, my lord.
Now
At this
it's
moment, my lord.
South Salmara and
Mankachar now, my lord.
Dhubri is still there.
Dhubri is still there, but that district has been bifurcated, my lord,
Bifurcated.
and a new district under the name and style of South Salmara Mankachar had been created, and we are only, my lord, concerned with that district, my lord.
Not Dhubri.
Not Dhubri as a whole. As a whole, not Dhubri, my lord.
In this petition.
In this petition. my lord.
What about the others?
No, my lord, other we do not have any grievance. Other perhaps some petition has been filed by my other writ petitions connected are also there.
The next matter is in respect of Dhubri district. In that case, Lordship, there is a stay order and selection process has not started. And Lordship, the government has not filed any affidavit till date.
No, no, no.
And in that particular case, Lordship, we have also challenged one particular clause. Lordship, wherein Lordship, the candidate should have landed property in his her own name. That particular clause is also under challenge.
This
In the
is
second,
what?
in the second writ petition. That is Lordship WPC.
This is item 2,
Item 2, Lordship.
the Dhubri district.
Dhubri district.
This item 1 is
Item 1 is South Salmara Mankachar, my lord.
86%, 87,
My lord.
120 Dhubri. And then
Then,
Lordship, there is one more writ petition pertaining to Lordship Sirang district. Item number, in that
9.
case also, Lordship, no affidavit has been filed till that.
9.
Lordship, that is BTC.
Then
I would be again my lord. South Salmara Mankachar.
which one?
Item number 10, man.
Ah,
We have challenged the selection of the private respondents who are in this partner.
and item 11 is mine, my lord.
And Lordship, in item 2 and 9, Lordship, no affidavit has been filed by any of the respondents.
Perhaps also in item number 10.
then what about others?
My lord, item 11 is mine, my lord, wherein, my lord, appointment of the private respondent is under challenge. And the, my lord, service is almost complete, my lord. My friend is appearing, my lord.
Item 11,
My lord.
same petitioners, different.
Yes, yes, no, my lord, same. It is, here is
Some of the petitioners
some of the
in item
petitioners, my
1.
lord. Here 67 out of 80, my lord. Some of the petitioners are here.
Item 9,
Lordship.
you have challenged the appointment of private,
No, Lordship. These are overall challenge, Lordship. Pertaining. This is pertaining to Lordship BTC. There, Lordship, the BTC will have to file an affidavit.
and then what about the others? 3, 4, 5, 6, 7, 8.
Item number 4, my lord.
Hmm.
Lord, we have basically challenged, my lord, regularization we are seeking, my lord.
Huh?
We are seeking, my lord, regularization, my lord.
Similar.
You are also appointed by villagers.
Villagers, my lord.
And which district?
My lord, Dhubri district.
Dhubri. Okay. Then item 3,
Yeah.
Item
In this case, in this particular case, affidavit has not been filed.
it's okay.
Well, I am one, I am for the respondent of 124 million 230 private respondent.
Completed.
Implemented,
No, which case?
serial number 1, item number 1, and we have been implemented as respondent of 124 to 130. And in this case, our only prior millard, we are also appointed by the villagers and we are working till date. That is our submission. And now millard, as per advertisement millard that was made millard on 19/5/2018, we have applied. And we are waiting that our interview should be held and we should be millard selected. But by the interim order of the court millard, the interim there is no selection. So our prior millard.
You said this
No, they are saying, they should be appointed as, because they have been appointed earlier
They
by
said
the.
initially there was an interim order, but then it has been modified and they have been appointed.
They have been appointed.
Appointed.
Our interview was not held.
Which
So,
district?
there is from Dhubri.
Dhubri process not started, madam.
Then you are, this is regarding South Salmara.
I am only concerned with South Salmara, Mankasa.
And I
They have
Enoch
mixed,
and
they have
also
mixed
said-
up Miller. South Salman and Dhubri, they have mixed, address is mixed Miller. So we are from Dhubri. So Miller, only our prayer Miller in for the student of 124 to 130, and let the selection process be completed as per as the government wants. And if we succeed, we will be appointed. If we are not succeed, then we will not be appointed. I have filed if it also.
It's okay. What about 3, 4, 5, 6, 7, 8? Same prayer. Let us see. 3, 4, 5, 6, 7, 8. Yes, what about item 3?
Item 3, my friend is here, huh? Okay. Tikuna.
The applicant filed by record number 1.
Item 3.
File on my lot. 65,000.
Which district?
This is the Dhubri district.
All appears to be Dhubri. Yes. Right. Yes, four. Which for?
Four is my friend,
Item
senior
four.
friend is appearing.
In respect of 4, my lord, last my lord, we are seeking my lord regularization. We are appointed by the villagers.
Villager.
Association,
Same footing.
same footing.
Same.
Any day,
Dubri district.
Dhubri district, my lord.
Then five.
Oh,
Item
bless.
five. Who is appearing?
Petitioner 5.
Regarding my lord, that same appointed by the villagers.
Deficit court fee in 3 and 4. Then 6, sorry, 3 and 5.
There been a class. It has been a spoke to nothing. Gonna be allowed.
Same. 6. Deficit court fee 7. Same. Same. Eight. Three, 5, 6, 7, 8. There's an observation of this court. There's a deficit court fee which the learned council has for which the learned council has granted time to pay the court fee
Deficit.
as in 2023. This has not been paid, so we are dismissing on this.
Which
Nobody is appearing.
3, 5 and 6.
3, 5, 3, 5, 6, 7, 8. Last one. No. 8. 3, 5, 3, 5, 7, 6, 7, and 8. Huh? Yes, what is to be done?
Milord,
Nobody is
one
appearing.
chance may be given as there.
Huh?
One chance may be given, Milord, as on behalf of my friends, Milord, I am submitting. Last chance, Milord. To
This
fill
has
up
been
the
listed today as a part-heard matter.
part matter. That is correct, Milord.
We'll dismiss it. Let them come back.
Because,
No
Milord,
prejudice.
regarding the court fee, Milord, they may not be
Hmm?
they may not be fully aware, Milord. That's the reason.
No, it was in their presence only order was passed.
I live up to your lordship's, Milord.
non-appears for the petitioner. Then it counsel for the respondents so and so. How many, all of you?
Lordship, I am on behalf of the Deputy Commissioner and Circle Officer, Lordship.
What a revenue.
Then two of you are present. This code on 28/06/2022. Having found that one writ petitioner has exposed the separate and distinct cause of action. No. Having found that there are more than one writ petitioner exposing separate and distinct cause of action. And only one writ petition has paid the court fee, or has granted the learned counsel to the petitioner on his submissions. Granted time to pay the deficit court fee before the next date. The matter was listed along with other analogous matters and heard on many occasions. On several listed and heard on several dates. Mr. Today, the analogous matters, including the presented petition, has been listed as a part of Mr. Herber. Known appears for the petitioners. And no court fees, no deficit court fee has also been paid, has been submitted by the land council for the petitioners. Having considered above, it appears that the petitioners are not interested to pursue this writ petition. Mr. The writ petition is still dismissed for non-contribution. In all the 3, 5, 6, 7, 8 separate orders. Let's see. Same order, that's it. Well, dismissing for default.
Default, yes.
They may not be interested. Then what about 9? What about 9?
Nine, Lordship, apart from the prayer for regularization, Lordship, we have also challenged the reservation policy. They have not kept any reservation for SC, ST, OBC. And secondly, we have also challenged that there is an arbitrary clause with regard to Lordship that the incumbent should have a landed property. We have landed property in her own name.
Which clause?
Clause 7
Clause 7 of what?
of the notification.
Page, what is the notification? You have been made eligible as per this clause
Other-
7.
Clause 7, Lordship. Lordship, we have landed property in our father or mother's name or our forefather's name, but not,
162(1).
yes, page 77,
They
Lordship,
have landed
clause 7.
Clause 7. She should have landed property, immobile property in his own name.
Which
India-
district?
This is in respect of Sirang district.
You're challenging the advertisement,
Clause 7.
huh?
Clause.
Are you challenging the advertisement?
No, no. No.
Why you have not filed affidavit?
Lots of the,
Additional affidavit filed,
Lots of that-
to the order dated 18/12/2019
Hmm,
regarding reservation
hmm.
in WBC number 3828.
3828, which one?
First item notice
38?
2008. There is an order notice in 18/12/2019
Hmm.
regarding reservation. Reservations we cannot be accommodate that. Why it will not be done? It is clearly stated in my affidavit.
also, but that particular notification is under challenge. Notification dated 10/4/2018, wherein that particular clause 7 is inserted.
And this is a policy decision, so we cannot get.
Lordship,
Policy
without,
decision.
and Lordship, in this case, Lordship, perhaps Lordship, the PTC council will appear. They have no role.
The deputy commissioner is the role. No, as a matter of law, you cannot claim for reservation.
They are seeking reservation. This is a single catapult. We cannot go for the reservation. It's stated in my.
Where is BTC? BTC?
PTC.
Where's the BTC?
The paragraph six.
We'll segregate this.
Lordship. And item number 2 is also same, Lordship.
Hmm?
Item number 2 is also same.
You are appearing with 2 and 9.
2 and 9. Lordship.
Hmm?
Yes.
2 they have filed.
2 read, Lordship.
2 they have filed petition.
Covered item number 3828.
Also, without
Huh?
serving a copy of the affidavit, what they have filed in,
I will, notice, I don't have now that.
no, they have, first they have to make a statement, Lordship, that this affidavit is covered in my case, Lordship. No affidavit has been filed, and this particular clause has been challenged in this in this writ petition.
Whatever this item 2.
Yes,
Item 2 is off,
item 2, Lordship.
is for what?
This is for, Lordship, apart from the prayer of regularization, I have challenged clause 7.
2 also.
In 2 also.
Hmm?
Yes, Lordship.
Then 9 also.
9 also.
9 and according to you, 9 and 2 are similar.
Similar.
Same challenge.
Same challenge.
So you need to answer that.
My lord, this is the. Dhubri district. Item number 2.
We are not passing anything. Whatever you have done, done. We'll
My
see.
lord, kindly go to that additional affidavit filing with.
See, in as per, according to him, as per clauses of the policy, the landed property, whatever, what's there?
Yes, the incumbent should have landed property in her own name.
Yes.
If the
So-
land is in my father's name, Lordship,
so
that will
you
not,
have
I
to-
will be ineligible.
You have to respond to that,
Yes, Lordship.
even if it's a policy decision, policy of the state. So where is segregating this?
Lordship.
After a week,
Lordship.
after a week,
Lordship.
can you file?
2 weeks.
Next. Item 2 and 3. And item
2 and
2 and 9. Not Mr. Sir, not concept of the petitioners. And Mr. J. Hendigan, J.K. Goswami. None concept for the response. None state concept for the response. Mr. Next, although these repetitions are listed along with WPC 3828 of 2018. From perusal of the pleadings. Pleading in the writ petition. The issue raised appears to be distinct from the issue raised in WPC 3828 of 2018. Accordingly, these writ petitions are segregated. Mr. the learned state council to file their affidavit invariably within 2 weeks, list after 2 weeks. We'll consider separately.
Absolutely obliged.
Then 2 and 9, huh? 10 and 11, we'll hear it separately after
Lord.
a week.
My lord.
All right.
My lord, then
And your this item 1
that cannot,
dismissed,
my lord,
dismissed.
my
I'll
lord,
pass the order, dismissed.
on merit.
Item 1, yes.
No, my lord can hear it along with the
No.
this petition after a week, my lord. Then my
Yes.
lord can hear my petition, my lord, today itself, my lord.
I've heard you.
No, I have not started hearing
What,
yet, my lord.
what you will?
My lord, I have not.
You are seeking, your grievances is,
My lord.
grievance is, you have been appointed as Gabura by the villagers. You have sought for regularization.
No, my
And
lord,
some steps has been taken.
My lord.
To that effect, you are relying some communication. In the midway, the authorities, as per the policy or the after a decision to establish or what appoint to create a post of Gabura,
Gavuras, my lord.
they have resorted to issue an advertisement filling up those posts.
My lord. Then what will happen to us, my
Therefore,
lord?
you
Because-
want that without completing the process which has been initiated,
My lord.
they ought not to have issued the advertisement
No, my lord,
filling up those posts.
my lord, we are not saying that the government is not powerless to issue advertisement or go for a fresh recruitment
Then
process.
Better
is within-
answer. If
No,
you are
but-
not saying so,
But my lord, when there is a case for our consideration, when there is a case for our regularization process has been initiated, that process should have been culminated to a logical end, my lord. That they have not done.
it's indicative. of
That's
it.
why, my lord, that's my,
Once they have decided to have a proper post, accordingly they have created it. While consideration of your while pending during pendency of consideration of your grievance,
my lord.
it is clear indicative.
Then, my lord, we will be ousted and we will be nowhere.
Yes.
Then, my lord, the service of rendered which they have, my lord, consume our valuable years of 15 years, my lord.
You
And
have
they have,
taken a risk.
my lord,
You
sir,
have not
kindly-
been appointed by the
no,
government.
my lord, what they have done, my lord.
Under what
My lord, my lord, with all respect, what I
who
humbly
has
beg.
appointed you?
No, my lord, I know my appointment, my lord, is not following the due procedure of law. It is in the
No, not even due procedure.
irregular manner, my lord,
Not
irregular manner,
irregular.
my lord.
It's void.
My lord, why I am submitting, my lord, because at that relevant period of time, for the purpose of recruitment of Gavuras in that particular
Nothing
area,
to do with the
there was
government.
there was no
See, this is
law.
by the villagers only.
My
To
lord,
your
My
convenience.
lord, similarly situated Gavuras in the Upper Assam district has been recently regularized, my lord. Those informations we are seeking, my lord, and we have found those also, my lord.
No, no.
That is similarly situated Gavuras in the Upper Assam district, my lord.
Yes, you are.
Now, my lord, that's why, my lord.
Though I have heard you, you are good. Tomorrow you may say that you have not been heard.
No, that I,
Yes.
no, my lord, that I will not.
What is your right?
My
To
lord, the right,
claim for consideration for regularization
that consideration has not been given,
or
my lord.
to complete the consideration.
That is very
Where is
limited.
where is
my
the
lord.
law?
My lord, the
There
law,
must be some basis.
no, the basis of law, my lord, I know, my lord, that there is no any institute or any something like
So-
that. Government has not created or not even an office memorandum for regularization, my
So
lord.
better and
The law comes from the Uma Devi to my lord Nihal Singh at this moment. And recently, my lord, my lord, I will rest my argument because my learned friend is smiling and he is not, my lord, hearing me, my lord. That I am making some absurd argument.
I am
and
hearing you.
I am very sorry, my lord.
Sir, I am hearing you.
My lord.
You continue.
My lord, what my
Yes.
respectful submission before my lord is that, my lord.
Hold your horses.
My lord, what my respectful submission before my lord is that, my lord, the government is well aware that the person concerned and the citizen of our class, my lord, has now been allowed by the government to work as an honorary Gavura, my lord. And the word honorary is that, my lord, that we are not getting any honorarium or salary from the government. Now, my lord, may kindly appreciate one document, my lord, which I have annexed, my lord, in the petition, my lord.
at page 43, my lord, page 43, annexure 2, my lord.
Yes.
Submission of proposal for notification of the Gaonbura lots with reference to the subject cited above, I am to inform you that the government in the Revenue and Disaster Management Department has created 497 numbers of Gaonbura lots in the district of Dhubri, white government notification under reference. Now, the lots are to be constituted comprising the total village area, etc. for publishing the notification. So, my lord, the district wise, this Dhubri district has been bifurcated and South Salmara has been shown as 82 million. Admittedly, my lord, on 2016 only this lot had been created. Before that, there was no Gaonbura system was there in the district of Dhubri or in the South Salmara Mankasa district. That's why, my lord, the government has allowed us. So you go, you should work, and my lord, we are rendering all help, all assistance to the government, my lord. Our valuable years, my lord. My lord, these are very people from the very lower strata, my lord. Now we have been utilized. Now the government is now proposing to throw out us.
Who has utilized you?
Government, my lord, because
Sorry,
the nature of,
sorry, you have not been appointed by the
no, we have
government.
not
So
been
how come is the
appointed by,
question of
but
utilization?
from the conduct of the government, my lord, they have a conscious decision, my lord, that we should be
Sorry.
allowed, my lord. My lord,
Until the time you show us
my lord,
semblance of
kindly turn
documents
to the next page, my
that
lord.
the
My lord,
government has appointed you.
my lord. No, my lord, I am, even my case is going to be
That's what I'm
dismissed, my
saying.
lord. I will not make any submission which is not
I
irrelevant.
understand. That's why I agree. And
My
you are
lord.
not supposed to also.
Now, my lord, kindly turn to the next page, my lord. At page 44, annexure 3, my lord.
Yes.
This is a prayer for a recognition, appointment as Gaonburas. This is the initiation of the process of our regularization, my
That
lord.
too submitted by ex-MP,
My lord.
ex-minister,
This
Assam
is a
member, all
forwarding
India
of our
Congress, which
application,
speaks
my
for itself. I'm direct to recuse so and so, so and so. It's
My
a
lord. That is correct, my lord.
forwarding of the
Now,
prayer,
my lord, now next page,
that
my
too
lord, at
by
page.
the ex-MP and ex-minister.
No, that MP and ex-minister, my lord, has, we generally what happened, my lord, in those days, my lord.
Sir, just forwarding of the grievance raised by someone.
And my lord,
Doesn't give a
our
right
particulars has also been collected by the
blame for
government.
all this.
Lord, our particulars has also been collected by the government by the notification.
Nobody is disputing, sir.
My lord,
This process, nobody is disputing. Even if they dispute also, I admit.
my lord.
I'll accept this. This process has initiated.
Lord, that's why,
It
my lord,
has not been brought to logical conclusion.
not brought.
But
to-
it doesn't mean that you have a right to be regularized or
No, my
considered.
lord, that right I am not asking for, my lord. My lord,
Because
what
if
my
you are
prayer,
not asking for
my lord,
what,
what my prayer is that the process which they have initiated,
no,
let them reject also, my lord.
no.
My lord may direct them that the process should
that-
be come to a logical conclusion by rejecting our
Sir,
prayer, my lord.
you know, it would be a futile writ.
No, my lord.
It will be, we don't issue,
Many persons, my lord, in the state of Assam.
sir, we don't issue a futile writ. That will be a futile writ. First, you have to show some semblance of
right-
right
My lord.
for consideration. If somebody on the instance of some ex-ministers, ex-ministers,
Not
or
ex-min-
for that matter, a present minister, unless you have the right, how can we direct?
No, my lord, minister's role, I am not, my lord, in that manner, they have not any role of that minister has also not asked for the regularization, my lord.
Sir,
Only our,
first, you have to show your right. On
Lord,
what
our
basis
right
your
for-
case can be considered and directed to be considered.
my lord, the right from the
You
Uma Devi,
participate, you
Milord,
may, you
even-
may,
even
you
in
may,
the-
you
even in
may,
the-
you may
Milord,
be selected.
my lordship is well aware, my lord, even in the Nihal Singh judgment in paragraph
No, what
20, paragraph 20, it
It's
had been
not
said.
relevant, sir. It's not relevant at all.
No, my lord, in paragraph 20, it
sure.
has been held, my lord, that the.
I'm
in-
sure it's not relevant.
No, my lord, what my respectful
Nihal
submission.
Singh, Uma Devi, no.
My lord can pass order, my lord.
Yes. You pass the order, this.
My lord.
That's why I want to clarify one thing. Annexing has just shown the annexure 3 lordships. Page,
No, Mr. Hendrick,
lordship, page 4.
admittedly, you have initiated a process.
No, lordship. My lord,
For
lordship, may
regularization.
kindly go to the page, annexure 4, page 45.
Hmm.
Just
What
for a
does it
moment.
say?
I want to show what is the, my lord, the guideline.
Ah.
There is a guideline, lordship. Lordship, may I kindly see with
No,
reference.
no.
No, guideline is given.
Nobody is disputing that.
No.
What he is saying is, you have initiated a process,
Lordship.
whether you reject or consider it or grant it, without bringing it to the logical conclusion,
But
you
this-
abruptly
This process,
decided to appoint by way of advertisement.
Lordship, this process has been taken in pursuant to the notification that is 6/1/2012, 2016, Lordship. There is no notification.
Where is the notification?
That was not annexed in our requisition. Lordship, may kindly goes to the
No,
notification.
no, which
in the-
one? Which one?
Lordship, may kindly
Page-
goes to the page 45 of the requisition 3282. Or
45.
3828, 45, Alexa 4.
35. Yes.
Lordship, my lord, third paragraph. The copy of the guideline white number, so and so, 6/2016.
3828. Writ petition 3828.
Lordships,
Page
page 45,
annexure 4.
Lordships.
Where is the third paragraph?
Lordship, my lord, kindly see that dear DMLR department dispose along with the enclosures and a copy of the guideline white R number 187. This is the notification. Lord.
Okay. Reference,
Lordship.
What my learned friend
government
is,
in revenue and DMLR.
Lordship.
my lord, what my
Ah,
learned friend is
this-
saying that, my lord, basing on this
Just
notification,
wait.
my lord, my lord.
Yes, what are you trying to say?
But this is the notification, what the qualification, what is, well, is there. Well, it pursuant to the those who are, this notification, some appointment has been made
By?
by the, my lord, selection committee, Lordship. There is a selection committee, deputy commissioner is the head. Well, this selection committee, those who are, my lord, working under the honorary, my lord, their regulation process has been going on, my lord, on that time. Later on, this notification, my lord, was, my lord, Captain Aviance, it was cancelled later, my lord, that 10/4/2018 has been come.
Where it is? It's your affidavit or are you just?
No, my
throwing
lord,
on
this
the
is coming
paper?
later on.
Has it been brought on record?
No, Lordship. My lord, we are saying that we are not going for the, taking any process for regularization. Lord.
Even in the
We have,
in
in our
they have
affidavit, we
not
have
denied
clearly
the
stated.
exercise, my lord. Affidavit, they have not denied, my lord.
This is what?
Just the,
Judgment.
that the notification, Lordship, who those who are, my lord,
Why you have been, why you have taken out from this? Sir, corpora, will I say this notification, it has to be bring on record.
Lordship, that is true.
There
And
are
my lord, that-
thousands of notifications. We'll have to deal with it a
my
particular
lord, that,
case.
no, my lord, I want to clarify, my lord, regarding that, my lord, that.
What you are
regularization
trying to
process.
say is,
Lordship.
the process initiated is as per the notification, what is this? Letter dated 7 March 2016, right?
Lordship.
Right? That
Lordship.
has been kept in abeyance by this notification.
My lord, that initially this notification was in person to this notification, some selection process was going on. Some of the, my lord, the district, they have been, my lord, appointed, my lord, that honorary Gaura. So, my lord, this has been come out, Lord. So, my lord, they are taking those who are working is the honorary Gaura. Their regulation process has been, my lord, going. But we are not going to the, my lord, taking the regulation of the, my lord, that petitioners, my lord, the case. We have clearly stated in our affidavit.
Yes, sir, I'm not able to get you. Just repeat it. The page 45 is, this is a addition by the additional deputy commissioner.
Lord-
Prayer for recognition appointment as Gaubura,
Gaura,
right?
Lordship.
Reference is 7 March 2016.
Lordship.
This is 6 month. Where is that notification?
This is a 6/1 notification. Lordship, may kindly read the middle portion, Lordship. My lord, death notification was sent to the on 7 March 2020.
Yes.
With reference to the subject cited, I am enclosing here with the copy of the letter under reference received by the Joint Secretary to the GovProp Assam Revenue and Disaster Management Dispute along with the enclosure, a copy of the guideline
White number LRR 187
Yes,
200 743 61 2006.
this is that. Yes, so
So I am request to kindly inquire the matter over the light of the guidelines and circular recently government of Assam
6120.
6120.
So
My lord, that if my lord in pursuant to the date notification, my lord, is any appointment has been made. So the government had taken a step for the regularization, those who are appointed in pursuant to that not
as per this.
lordship.
So according to
They are not appointed in pursuant to the. my
no,
lord,
no, their process has not been initiated as per
no,
this.
lordship. In our affidavit, we clearly stated, we have not taken any process for the regularization of.
What
the
about
application.
these communications? What about these communications? See,
Lordship, these are the communication, Lordship.
Joint Secretary to the Government
Yes,
Assam, Revenue
these are the
DM.
page 44, Lordship.
Yes,
These are the communication, Lordship. It is not through any guidelines, Lordship. These are the
it's
communication.
okay, but then you have initiated the process, then come to page. Subjects have to, you submitted the present by 9 members of applicant,
It is 46, Lordship.
46.
Yes, 46. Lordship, these are the communication, but not as per the rules, Lordship.
And the
And
page 49, additional deputy commissioner, circle officer,
these are the mere communication without having any rules, Lordship. Without going through, without as per rules.
circle
Lordship.
officer,
These are communication, Lordship.
by your officer only.
Lordship, I do admit it, but these communications are not as per the guidelines, Lordship. These are the mere communication. Therefore,
This is the guideline.
yes, Lordship.
These are the guidelines.
Yes.
Is this the guideline?
Lordship.
61 2016. Right?
Lordship. Earlier, my lord, 2001 notification was there 2000.
Where is your affidavit?
Lordship. In the affidavit, lordship, filed by respondent number 1, lordship. In 38.
Yes.
The one additional affidavit file, lordship, 18/12/2000 in order pursuant to the order dated 18/12/2018. Lord.
Affidavit in opposition or
Additional affidavit
where it is?
in 3828.
Additional affidavit. 1812.
1812, order dated 1812. File, my lord, that
No, when did you file the additional affidavit? Should be
I forgot the date.
103.
One is file lordships by respondent number 1, Dilip Kumar Das. Date to night.
Additional affidavit. Dilip Kumar Das, yes.
Lordship. It's the 2020. So in the paragraph 5, my lord, we have stated that there are Deputy Commissioner Dhuburi informed the by letter number so and so, that so and so. So no honorary Gawa was appointed by the government, by the Deputy Commissioner Dhuburi in respect of Dhuburi districts.
No, that there he is admitting fairly.
And
That
lordship,
they
kindly,
were appointed by the villagers,
Lordship.
not by any government officers or by the government. They are admitting it. His case is very simple.
lordship.
Since you have initiated In other words, since you have processed their grievance,
Lordship,
you ought to have
rejected or
brought it on its logical conclusion, either rejection or either rejecting or accepting. Without that,
that
you have suddenly issued the advertisement for filling up the post.
Right.
That is a
Right.
claim.
another,
Yes, it's more clearer.
No, that is correct, my lord. My
And
respect.
some of the additional deputy commissioners on your approach
My
have they provided your
particulars
but
has been
that's all. Nothing
transmitted to
else.
the government, my lord, as sought for by the revenue department, my lord. That what can be done.
Sir, unless you show some basis of your claim, and fairly, you have said that there's nothing, no basis.
No, my lord, my lord, when there is nothing, my lord, I cannot bring, my lord, or I cannot submit falsely before my lord. But only thing, my lord, by the conduct of the government, the right had been accrued, my lord.
Sorry.
The conduct of the government is
That's why
that.
I'm saying it's only by some of the officers of the government.
No, officers.
Circle
no, it is
officer
the-
and the additional, who doesn't have the authority to decide.
No, my lord, with my
They simply
limited.
provided your case, that's all.
No, my lord, with my limited understanding, those officers has not acted on their personal capacity. They are acted on behalf of the state, my lord. It is the state decision, my lord, that the process should come to they can reject straight away within a speaking order, my lord. That, my lord, generally, my lord, in many cases, my lord, when we approach
Sir,
before my
for
lord, my
that,
lord.
you have to show some semblance of right.
That
What
process,
is
my
your
lord,
right?
my lord, the
Just
right,
because your prayer has been provided and the case has been provided, without there being any right
no, my lord, the right
accrued to
accrued,
you, how
the
can
right,
you insist on that?
my lord, the right accrued.
Can you pass and issue a writ to the authorities to reject your case?
No, that is not the issue, my lord. Our only thing is that, my lord, our process should be come to a logical end by way of the relevant provision of the law. Now, if the law does not allow us, they have the every power to reject us, my lord. My lordship's, we are seeking my lordship's intervention only for the
We
purpose.
cannot intervene
My lord,
like this.
in many cases, my lordship has intervened, my lord, in such a situations, my lord, in other issues, my lord. That when we made a representation that is pending, we approached before my lordship issued a mandamus that you consider that. In maximum cases, those consideration is come out as a negative result.
When?
No, my lord, in some other cases, when we approach before my lord, not in the Gaumura's.
So we have developed now.
My lord. My lord.
See, Mr. Bhuya,
My lord.
as you know, it's no point whispering to the wind.
That is correct, my lord.
Dismissed.
Up to my lord, my lord. The word dismissal is very pathetic for these people because, my lord, they are.
Unless
lord.
you, that's why I said you withdraw, pursue a better pursuit.
Withdrawal, I have taken the instruction
So-
of my personal capacity, it will be risky, my lord.
We are also not happy with the use.
No, but my very limited.
We don't,
my
we
lord.
don't pleasure to use the word
No,
dismissal.
that is correct, my lord. My only limited prayer, my lord, can remand the matter to the government with a direction that the process which they have initiated, that should be a come to a logical end.
As you know, we're here,
My lord.
all of us,
My
to
lord.
render justice,
That is
not
correct.
only to the petitioner,
My lord.
equally the other side,
My lord.
on the basis of the right and the law.
My lord. That I can, my lord. I have the feelings, my lord.
So nobody draws a pleasure by using the word dismiss.
My lord.
In that case, we'll close the petition rejecting your the claim or the case.
My lord.
Reverse. Without saying the word dismiss.
My lord.
Okay. Item 10 and 11.
My lord, item 10 and 11 is a separate issue, my lord, that can be heard on some
That
other
can
day.
be heard next week. When?
Any date, my lord. But my lord, affidavit is required in 10 and 11, my lord.
But both this,
Because
there, yes, affidavit has not been filed.
challenge the selection
process.
Yes.
Yes, come from them.
Fine.
And have you made the party to those selected persons?
Yes, selected persons are fine.
Yes, all selected persons are party, my lord.
And
They
notice,
appeared on KBL.
they appear on KBL.
KBL.
Yes, you are for selected persons.
I have already filed it.
Okay, yes, government.
I will, I will.
So after 2 weeks.
After 2 weeks, my
grant
lord,
them,
may-
10 and 11,
and the item one judgment will be CAB, my lord.
not CAB. We'll decide today itself.
My lord. Sorry, my lord, I heard it on some other way.
No, I'll try to dictate it there. I mean, I'll pass the order in
My lord, my lord,
chamber. Today itself.
my lord.
Item 10 and 11. Heard Mr. Swenson.
Item 10, my senior friend is appearing, and 11 myself, my lord.
Yes, Mr. D. Armajum, counsel for the petition in WPC 6178 of 2019. And Mr. A.R. Boya, counsel petitioners in WPC 8394 of 2019. And
I'm for revenue.
yes,
I am on behalf of the Deputy Commissioner and Circle Officers.
as well as Mr. S. S. Islam, counsel for respondent 4 to 67. And 10, item number 10.
10 and 11, 1 to hold.
By 10, madam, I am from 7 to 12, madam.
Okay, 7 and 12, 7 to 12. The private respondents have already filed their affidavit. However, state is yet to file their response. Therefore, no, accordingly, the state respondents are granted for the 2 weeks time to file affidavit. List after 2 weeks.
My lord. I know.
Yes, item 4. Yes, item 4.
For my friend is appearing.
This will be dismissed along with item 1.
One.
Item 4 and 1. Yes, next. Yes, Mr. Buya, I have heard you enough, right? Are you satisfied?
My lord, my lord. Highly obliged. My lord, may I have the permission to leave, my lord?
Yes, yes,
My lord.
obviously. Yes, item 12.
Item number 12, synopsis.
Hmm.
For-
What is the issue?
Yeah, what has happened
You
is
said
here-
already been the earlier
Yes.
round of, it's a covered case.
The subject matter is covered, whether we are nursing assistants or nursing personnel or not.
Hmm.
The allowance name is different.
That's right.
That is where it stands today, madam.
Hmm.
Page 29 is the first,
29.
page 29.
Hmm.
Is where the fight starts, my lord. Page 29, it's a office memorandum of 12th of January 2018.
Hmm.
This says dress allowance to nursing personnel, implementation of recommendations of the 7th Central Pay Commission regarding.
Hmm.
Consequent upon the decision taken by the Government of India on the recommendations of the 7th Central Pay Commission, White Ministry of Finance Regulation so and so, in supersession of the existing orders leading to uniform allowance and washing allowance, which have been subsumed in a single dress allowance.
Hmm.
The President is pleased to decide the rates of dress allowance at the rate of 1800 per month in respect of nursing personnel
Hmm.
of CAPF, AR, and NSG eligible for it.
Hmm.
Now, we are, my lord, nursing assistants serving in AR, Assam Rifle.
Hmm.
Following this, my lord, when we were not paid, and this was to be made effective, serial number 7, lordship will find
You are
First
nursing
of-
assistant.
assistants.
Hmm.
We are nursing assistants.
Yes.
Then lordship will find our representation at page 30. Para 6.
On another hand, nursing assistant from Assam Rifle who are now on deputation and National Security Guard has received dress allowance. Others were receiving in the other CAPA. 7. It is a settled position in law that the nursing assistant form an integral part of nursing personnel in the Assam Rifle given by the several judgment of the competent Honorable High Court and Supreme Court. For example, judgment given by Honorable Guwahati High Court and Honorable Supreme Court with related to grant of nursing allowance to nursing assistant. With respect to Naib Subedar so-and-so clarified that nursing personnel included the nursing assistant for all practical legal purpose. Therefore, I request you to kindly sanction the dress allowance. This was a representation made. The answer came at page 31 from the DGAR, that is the Director General, Assam Rifle. Para 2, I will read, madam. As per directions of FA, Assam Rifle, clarification of the matter was sought from other CAPF and it was clarified that only nursing personnel who are possessing Indian Nursing Council approved qualification and RM or registration certificate from State Nursing Council are being paid the dress allowance at the rate of rupees 800 per month. Keeping in view of the same, it is stated dress allowance at the rate of 800 per month will be entitled to only those nursing personnel who possess the qualification as mentioned in para 2 above. Copy of MHA number so-and-so and so-and-so are also enclosed. Other personnel are entitled annual dress allowance at 10,000 per year as per MHA OM dated 17 August 2017. This is when we approach this honorable court. Now, my lord, whether
So instead of 1,800 per month, you have been allowed
yes,
10,000
10,000 per
per
month we are getting.
Okay.
Our claim is that we should get 1,800 per month. Now, the only issue which was taken up in this rejection letter is that persons who have got that certificate or are registered under the State Nursing Council are entitled.
Difference would be how much?
My lord, different
18 into 12.
difference is huge, madam. Difference would come to huge over the years.
21,600.
Just 50%.
My lord.
10,000.
Now, my lord, when the first issue came up as to whether the nursing personnel would be nursing assistant would be included in the term nursing personnel, the first issue came up at page 32 by an office memorandum of 2009, which was with relating to the nursing allowance, which was to be made available. Payment of nursing allowance to the nursing personnel of CPF at the rate applicable to the nursing personnel of central government hospitals.
Where it is?
Madam,
Where
page
it is?
32, I am reading, madam.
Ah.
Here, my lord, the issue was payment of nursing allowance.
Hmm.
Now we are on the issue of dress allowance.
Hmm.
Subject, payment of nursing allowance to nursing personnel of CPF at the rate applicable to the nursing personnel of central government hospitals. Here, my lord, it was granted only to nursing personnel.
Hmm.
When they refused us exactly on the same ground, saying that you do not have the qualifications of nurse, we approached the Honorable Guwahati High Court at that point of time, the Shillong bench. Lordship will find the judgment at page 34.
Hmm.
The Lordship has the crux of the matter at page 42. Why it was being rejected at that point of time. Para 12. What was the stand of the respondents? The respondents have filed counter affidavit denying the claim of the petitioner. In this connection, it has been stated that nursing assistant have been specifically excluded from the purview of nursing allowance as per OM dated so-and-so. Although the copy of the said OM has not been annexed to the counter affidavit, the same has been produced during the course of hearing. It has been contended that for entitlement of nursing allowance, special professional qualification are required as per recruitment rules applicable for recruitment of nursing staff of Assam Rifle. According to the respondents, on the basis of the prescribed qualification for appointment of nursing assistant, they are not entitled to nursing allowance. The same ground was taken. Then Lordship will find the findings of the court at page 49. Para 22. The office memorandums referred to above do not make any distinction between the nursing staff with diploma and or certificate and the nursing staff without such diploma and or certificate. Had it been the case, the said OMs would have specifically spelled out the same. On a total reading of all the OMs, there is no escape from the conclusion that the nursing allowance is applicable to all nursing personnel and staff. The respondents themselves had admitted in their counter affidavit that the nursing assistants form an integral part of the nursing staff, but at the same time have stated that the same by itself will not qualify them for grant of NA without, however, specifying anything as to why they are not entitled to the same being integral part of the nursing staff. The expression personnel means people employed in an organization or engaged in an organized undertaking. The expression used in the various OMs is nursing personnel who are entitled to nursing allowance. In the said office memorandum, no distinction has been made on the basis of qualification, etc. All pervasive expression used in the OM is that the nursing allowance should be applicable to all nursing personnel working in central government hospital. Then Lordship will find at page 51. For all the aforesaid reasons, the prayer of the petitioner in acceptance of the writ petition is allowed. It is hereby declared and ordered that the petitioners are entitled to nursing allowance at par with other nursing staff from the respective date of applicability of the same at the prescribed rates. Respondents are directed to provide the petitioners with the benefit of NA as expeditiously as possible. This was taken up by the respondents in a writ appeal, which Lordship will find at page 52. The relevant portion Lordship will find at page 60. Para 27. Can we read? Para 27, I mean. We have given our anxious consideration to the arguments advanced by the parties, keeping in view the materials on record. On a very careful perusal of the materials on record, we have found that the entire argument advanced from the side of the appellants is found on the assertion that in view of the conditionality made in the office memorandum dated so-and-so, 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 more particularly in the office memorandum dated 28/7/2009, nursing allowance can be paid only to those nursing personnel who are having professional qualification prescribed by the RR or SR and none else. However, on reading of the aforesaid memoranda in between the lines in juxtaposition with the recruitment rules of 1980, we cannot pursue ourselves to come to a proposition put forward by the learned counsel for the appellants. In our considered opinion, office memorandum dated so-and-so, more particularly the recruitment rules, do not suggest even remotely that nursing allowance can be given only to those nursing personnel who possess special professional qualification. Then Lordship will come to page 30, para 31. The decision aforementioned has again reaffirmed the view that appellants cannot be allowed to give a new meaning to the term nursing personnel on the basis of subsequent notifications or recruitment rules in order to deprive them from getting the benefit provided by memorandum referred to above. We may note here that on making assessment of the memoranda aforesaid as well as the recruitment rules referred to above, we have found that if any distinction between nursing staff vis-a-vis the entitlement of nursing allowance needs to be made, then such distinction cannot be made on the basis of educational qualification alone. Rather, it needs to be made basically on the basis of duty entrusted to the various nursing staff. Opinion rendered in judgment dated so-and-so doubly confirms our above proposition. On a careful reading of the duties of nursing assistant, it would appear clear that nursing assistants who are admittedly integral part of nursing staff are basically entrusted with the duties of nursing the patients, and therefore the duties they discharge are very much like the duty discharged by the other nursing personnel such as assistant matrons, sisters, staff nurse, and auxiliary midwife nurses. On perusal of various duties entrusted to nursing assistants so mentioned in annexure so-and-so, it makes more than clear in view of the above matter, two writ petitions are already held to be nursing personnel are when entitled to nursing allowance above mentioned. And therefore, till this point of time, it was very clear that nursing assistants are nursing personnel entitled to the allowances to be given to nursing personnel. Accordingly, at page 63, they were given the nursing allowance. But in another round of litigation, this is the next round of litigation, which was not available at the time of filing the writ petition. Another batch of writ petition was allowed depending upon the writ appellate judgment. That Lordship will find at the top. It is writ appeal number 31 of 2014 in WBC 256 of 13. Lordship should kindly come to page 7 of the judgment. Running page 7. Para 4. Learned single judge in all the writ petitions from which these appeals have arisen following the judgment and order dated 25/5/2012 passed by the division bench of the Guwahati High Court in writ appeal 1, Shillong of 2011, directed that since the writ petitioners, that is the present respondents, being nursing assistants are covered with the expression nursing staff, as such, they are also entitled to nursing allowance in terms of order dated so and so quoted above. Then at the end, my lord, at paragraph 8, no other point is placed in these appeals for the reasons discussed above. We have the view that there are no force in the writ appeals which are liable to be dismissed. Accordingly, writ appeals are dismissed. The appellants are allowed to comply with the impugned orders passed by the single judge within a period of 6 months from today.
The single judge was.
Single judge depended on the order of the writ appeal which I had just read out in the writ petition, which was annexed to the writ.
Okay.
These were separate batch of writ petitioners who did not approach the honorable court along with the first batch of writ petitioners and were being denied only on that ground. So they came before the honorable court.
Nursing allowance is concerned.
Nursing allowance, same, my lord. Whether they are nursing personnel, nursing assistants or nursing personnel or not. And at para 5, if lordship will find at page 8, learned counsel for the appellants submitted before us that the appellants are confined the challenge to the imputed orders only to the extent that in view of the law laid down by the apex court in state of Madhya Pradesh and others versus Yugandhar Srivastava, area and allowances could not be directed at para 5 on the next page. So in the second round of litigation, the respondents gave up the argument that nursing assistants are not nursing personnel. And they tried to restrict their arguments only to the extent of areas which can be given to the respondent, to the nursing assistants. Having failed in this appeal, they then approached the Honorable Supreme Court, which is on the next page.
It has been dismissed.
We do not find any reason to entertain the petitions, especially petitions are dismissed. Having not paid the nursing allowance to the nursing assistants again, contempt petitions were filed, which is on the next page. Then lordship will find the order on the subsequent page. When notice was issued, the last page of the compilation, what the respondents say. Contempt petition diary number so and so, this is ordered by the Assam Rifles. Para 2, lordship will find. It is intimated that nursing allowance has been granted with salary bill of September 2024, which was stopped erroneously. Balance area will be paid. So the entire issue as to whether the nursing assistants are part of nursing personnel or not is settled up to the Supreme Court. Their only ground for rejecting us the dress allowance is that we do not have the qualification. That has already been settled by this honorable court, division bench.
So according to once you are held to be
integral part of nursing
integral
personnel.
part or as a personal nursing personnel,
My lord, I would be
you are
entitled
entitled to all the benefits as granted to the
nursing personnel,
nursing personnel,
including
the
an extra one, the dress allowance. That is my case. That is precisely what I have given in the synopsis.
Definitely, your lordship. In earlier cases, my lord, that is in page number 49, the observation of the court was that in page number 20, para 22, page 49, the office memorandum referred to above not make any distinction between the nursing staff with diploma and or certificate and the nursing staff without such diploma or certificate. Had it been the case of said OM would have specifically spelled out the same. On a total reading of all the OMs, there is no escape from the conclusion that NA is applicable to all nursing personnel staff. The respondents themselves have admitted in their counter affidavit a nursing assistant from integrated part of the nursing staff, but at the same time, they stated that same by itself will not qualify them for grant of nursing allowance without, however, the specifically anything as to why they are not entitled, the same being the integrated part of the nursing staff. The expression, next paragraph, my lord. The expression personnel means the people employed in the organization or engaged in an organization undertaking. The expression used in the various OMS is the nursing personnel who are entitled to nursing allowance. In the said OMs, no distinction has been made on the basis of qualification. All perversive expression used in the OM is that the NA would be applicable to the all nursing personnel working in the central government hospital. That is regarding the OM dated 28/7/2009. The Honorable Court observed that, my lord. And OM is, my lord, in case number 2009. OM is in case number.
Page 32.
কৰিছিলা ন? 32?
28 July.
নাই, কৰি আছো। গৈ আছো ৰবা তাৰমানে। নাই, নাই।
তোমালোকে নাই দিয়া, মই দিছো।
মই দিছো না?
মই দি দিছো page 32.
52 আছিলে নেকি? Yes, my lord. Case 32. Case 32, my lord, in paragraph 2, that is also observed in the same that earlier cases.
Yes.
May I read page, paragraph 2, my lord?
Yes, yes, also.
The above rate of nursing allowance will be applicable only to those nursing personnel who are entitled for the payment of nursing allowance as per their recruitment rule and service. There is nothing regarding the, my lord, certificate or national certificate, my lord, nursing certificate. But it has been amended, my lord. Then kindly come to the page number. Page number 78, my lord. Our affidavit in opposition.
Affidavit.
Yes, my lord. Our affidavit, page number running to 78. May I read that, my lord? That is letter dated 21/9, OM dated 29/1/2013. The undersigned is directed to state that in partial modification to the ministry's order of event dated number 28/7, that is that of office memorandum, on the above subject para 2, the order will be read as under. All nursing personnel are eligible for nursing allowance as per Ministry of Health and Family Welfare OM dated 28/7/19. However, to practice nursing, it is essential to possess registration certificate like RN, RM, RNNM, etc. from the State Nursing Council. And also the nursing program has to be recognized by the Indian Nursing Council. Therefore, the personnel possess the INC approved qualification and RN, RM or registration certificate from the State of Nursing Council are eligible to practice as a nursing personnel and therefore eligible for nursing allowance, my lord. And after that, my lord, that 1800 dress, that impugn notification, that is page number 82, where it is specifically stated that dress allowance to the nursing personnel. And nursing personnel, that has been amended, my lord, who are the nursing personnel by the OM dated 29/1/2013. At that point of time, my lord, when that other earlier matter came before the court, this is not amended, my lord. So in the dress allowance, my lord, and accordingly, and 1800, that is the dress allowance, my lord, that has been given consequence upon the decision taken by the Government of India on the recommendation of 7 Pay Commission in suppression of existing order relating to the uniform allowance and washing allowance, which have been subsumed in a single dress allowance. The President is pleased to decide the rate of the dress allowance at the rate of 1800 per month in respect of the nursing personnel. Nursing personnel has been defined by that notification, my lord. Nursing personnel of all categories at all level working in the central government, UT hospital institution and central funded amounted autonomous bodies like AIMS, New Delhi, that is. And my lord, for them, my lord, nursing assistant, my lord, they have given 10,000, that is page number 79, my lord. Same thing, my lord, as per 7 Pay Commission, my lord. That is, may I read page number 79, my lord?
79.
Yes, my lord.
Yes.
Consequence of the decision taken by the government on the recommendation of the 7 Central Pay Commission by Ministry of Finance resolution that so and so in suppression of existing order relating to the uniform related to the allowance by uniform grant, kit maintenance allowance and the washing allowance, which have been submerged in a single dress allowance And the President is pleased to decide the rate of dress allowance in respect to the personnel of the Central Armed Force, Assam Rifles and NSG as under that is given as a 10,000, my lord. And for that, the petitioner is entitled for that 10,000, not for the 1,800 per month, my lord. Because the nursing personnel that has been defined by notification dated amended notification 29/1/2013. At that time, that notification is not there. Amendment was not done, my lord. When writ appeal was filed and before go to the apex court. Nothing.
2014 to Malapur.
Oh, 14.
You are talking of 13.
Appeal come petition of a he said. Writ appeal of the country.
Yes.
And in the writ petition specifically stated that earlier writ petition, my lord, that is saying about the 2009 notification, 28/7/2009, there is no specific criteria for nursing assistant and nursing personnel, my lord. So that is, that OM has been amended in 2013, my lord. So as per this amendment, they are not entitled for nursing 1,800 per month. They are entitled for 10,000, my lord, per year, my lord. As per this notification, my lord. That is my submission, but they are not, 1,800 is not entitled for that, my lord. And they are given the 10,000 per year, my lord. Same, my lord, dress allowance, my lord. Page number 79 is for the dress allowance for the, except that my nursing personnel, my lord.
PBORS of CFP, what is this?
Which one, my lord?
PBROS, page 79.
Page 79, yes, my lord.
What's
Page
the full form of this?
Central PBO to P homo. One is NSG, one is Assam kita. CAPF petition.
Other
Central.
officers.
Mhm.
OR is other rank.
PB
OR
is
is
what?
CAPF is Central Armed
No.
Police Force.
PBORS.
PB,
OR is other rank.
PB is what?
PBL.
PB to PSC. Demolition. Officer of CAPF, PB.
That is the officer and gazetted officers.
Officer, officers of officer hobo kiba eta officer hobo.
No, other rank. PB is other rank.
PB.
Personnel below officer rank. PBOR. Personnel below officer rank. Other rank, officer rank. Personnel below officer.
So you are nursing assistant.
I am licensed.
But you are not nursing, what is called?
Nursing
We are not
personnel.
nurses. We are nursing assistants.
Okay. So the nurses are getting 1,800
Yes, ma'am.
1,800
per month. So by this page 78, according to you, yeah,
Page 78 is
By this, they attempted to modify the definition of nursing personnel after the judgments rendered by this honorable court in the writ petitions. My humble submission that itself was contemptuous, and therefore, when other writ appeals came before this honorable court, this was never pressed into service. First of all. Secondly, my lord, this is only with reference to the nursing allowance part. Even after this office memorandum being in existence, when they went up to the SLP, this was never brought into force. Thirdly, in the year 2024, they say erroneously we stopped the payment. Let us continue to make the payment. So therefore, this attempt at trying to change the definition or finding of the code by an office memorandum by an executive authority, here's no, my lord, it will have no connection with the repetition.
but then the basis of the learned single judge
Yes.
is there is no distinction.
Lordship will find the learned single
Regarding
judge.
the,
This was a ground taken, and Lordship will find that if it, the learned single judge's decision, Lordship will again come to.
and on that basis, this,
That was not the only basis. I had not read it to the full extent. I'll read it now. The learned single judge has held that if it is only restricted to nurses or with people with qualification, then A&Ms will also not get it because they are not registered, but they are getting it. So their very basis is wrong. That part Lordship will find. Yes, para 20. Although in the contract, the respondents have stated about exclusion of the nursing assistant by the state order dated so and so, and their whole basis for denial of any to the nursing assistant is that the same is applicable only to the nursing staff from whom there are prescription of any in the recruitment rules. The basic contention of the respondent is that the petitioners, and for that matter, the nursing assistant, do not confirm the requirement of prescribed professional qualification entitling them to any. In this connection, they have referred to the recruitment rules as amended in 2001. In the recruitment rules, there is nothing to indicate that the nursing staff with the particular qualification are only entitled to nursing allowance. The recruitment rules only indicates that the post of sister, staff nurse, civilian compounder, midwife, auxiliary nurse, veterinary field assistant, rifleman clerk, and rifleman nursing assistant are indicating their classification, scale of pay, age limit for direct recruitment as to whether the posts are selection or non-selection. Qualification and other criteria for the post cannot be decisive of the question as to whether they are entitled to nursing allowance. There is nothing in the RR to indicate the grant of any to any category of nursing staff. The same has been placed reliance by the respondents only to indicate the pay scale and other parameters for the appointment to the post. Now, the definition which they have tried to modify in 2013, as they say, will not be applicable to 2018 because they are two different office memorandums. And 2018 does not refer to 2013 amendment. That amendment, Lordship will have again the page 78 part. It only amends the office memorandum of 28/7/2009.
yes,
It does not in any manner, cannot, because it is prior in on date to 12th of January 2018. They are two very separate allowances. The only condition that requires the consideration of this honorable court is whether the term nursing personnel as used in office memorandum dated 12th of January 2018 under which we seek an entitlement, whether that nursing personnel definition will cover nursing assistants or not. When it does not lay down that it will be as per the educational qualification. In fact, their own affidavit in opposition, Lordship will kindly have page 80. 2. Dress allowance to the nursing personnel, implementation of recommendation of the Central Pay Commission. Consequent upon the decision taken by the Government of India to the recommendation of the 7th Pay Commission in supersession of the existing orders relating to uniform allowance and washing allowance, which has been subsumed in a single dress allowance, the President is pleased to decide the rate of dress allowance at the rate of 1800 per month in respect of nursing personnel of all categories at all level working in central government hospitals.
Yes.
It is applicable to nursing personnel of all categories working at all levels. And even in this, there is nothing relating to the educational qualification. What has been pointed out at page 78 was only in relation to this 2009 office memorandum. This cannot have a bearing on this was by the 6th Pay Commission. What has come in the 7th Pay Commission cannot be governed by what was laid down for the 6th Pay Commission. They try to modify that office memorandum. But yet, when they went up in appeal or even to the SLP, Lordship will find this is of 2013. The judgments that have been placed before Lordship, this compilation which I gave. Lordship will find the appeals, the writ petitions are of 2013, which were disposed of on 19/9/2013, much after this alleged page 78. Page 78 is of 29/1/2013, Lordship finds. And the compilation I had given if Lordship has at page 9. The impugned orders passed by the learned single judge in the writ petitions number so and so decided on 19/9. WPC number so and so decided on 5/9. WPC 257 decided on 5/9. Every of this writ petition was decided after this alleged 29/1/2013. Even before the Honorable Supreme Court, this 29/1/2013 was never there. It comes up in this affidavit in opposition, trying to modify an office memorandum of 2009. Our claim is based on an office memorandum of 2018. The recruitment rules have not been amended. That is not the stand. And in my
basis is of 2018.
My lord,
Your basis is of 2018.
yes, 2018 Lordship will find. An extra one. The dress allowance which I am seeking was introduced in 2018. Page 29, my lord, of my writ petition. At the top, North Block, New Delhi, dated 12th of January 2018. The judgments of the Honorable Guwahati High Court, the division bench judgment were referred to in this writ petition to show that nursing personnel will include, nursing assistants will be included in the term nursing personnel and will be entitled as per the earlier decisions of this Honorable Court. Here also they use the term simply nursing personnel. Last line of the first paragraph.
Please, Your Lordship. The writ petition was disposed of on 2010, my lord. Before the, yes, writ petition. And 2010, my lord. And writ appeal, dispose of, writ appeal.
There are two sets.
Writ petition 2010, my lord, and writ appeal had arose from the writ appeal. New fact cannot bring my lord in the writ appeal, my lord. That is 2013, 2013, my lord. Well, that matter is of 2009, my lord, at that time, this amendment was not done, my lord. And amendment was done in 2009 at the pendency of these cases, my lord. So we cannot.
Are you saying that the basis of the judgment has been removed
Yes.
by this page 82?
78.
78,
78 was, that is what I'm insisting.
where you have issued a notification
Yes, my lord.
clarifying the meaning of the
Nursing
entitlement nursing.
personnel.
whatever. Clarification, I think.
Yes, ma'am.
Are you saying so?
My lord.
Are you saying that, are you submitting that this, after the judgment,
Yes, my lord.
this is by of removing the basis?
No, no, that is not after judgment. It is to KPIs.
It was after the retaping. Retaping was, first retaping was decided in 2012.
Yes,
Then
my
they
lord.
tried to remove that basis by introducing 2013. When the matter goes up to the Honorable Supreme Court dismisses
But-
the SLPs.
Yes,
And
ma'am.
Supreme Court or not on merit?
Then
Yes,
second
my lord.
batch, Lordship will
no-
find the
the-
second batch. The second batch of repetition. We again file after
And
the
they-
office memorandum clarification.
They are,
Still, we are granted the relief.
but they are claiming 1800 on the basis of, my lord, earlier cases, my lord, that, and that case, that is depends
No,
on
no,
2000.
issue is regarding the issue is whether the nursing assistant are also falls within the meaning of personal, nursing personnel. If they're
And
as held by the single bench as well as division bench, if they falls under within the definition of personnel, nursing personnel, they are entitled. Because
in
nurses are getting 18
1800
per month.
per month, yes, my lord. And they are getting 10,000 per year, my lord.
Yes.
Dress
Why?
allowance, my lord.
Why? They are
Because-
also,
Because of, that is because of this 2013 OM, my lord, because nursing assistant required, my lord, that certificate, my lord. Certificate of Indian in Nursing Council, but they don't possess that certificate. The petitioner, my lord, don't possess that certificate, my lord.
no, in this page 29, you said in respect of nursing personnel, CA, PF and AR so and so.
See,
Yes.
Central Armed Police Forces, Assam
Yes,
Rifle
nursing
and nursing personnel is the simple word used.
Yes, the nursing personnel, and nursing personnel has been defined by this letter, my lord, 29/1/2013.
20.
9/1/2000, that is amended part, my lord.
That's why, are you saying that this court, the single bench as well as FIM division bench has said that personnel, nursing personnel includes the nursing assistant?
Yes, my lord.
So,
That division bench has said on the basis of 2009, my lord, that is 2009
so
OM.
are you trying to say, that's what I'm saying.
Yes, ma'am.
You have the power to remove the authority to remove the basis of the judgment.
Yes.
Are you saying so? Mr. Majumdar, what is the judgment?
My lord,
There is a judgment of Justice Goya also, latest.
cannot be removed.
I think 2 months, 1 month back.
Yes.
Removal of the basis of the judgment, relying on the earlier judgment. Continue tomorrow.
My lord, yes,
I have
sir.
understood what you are trying to say,
Yes, ma'am.
and also
Yes, ma'am.
you too, but then let
Yes.
us
Their judgment,
hear on that issue.
Yes, ma'am.
whether they
He's in there, he's directly, I mean, he's trying to say, I don't know whether I made him try to, I mean,
Yes,
whether I have properly come.
no, no, I got the point, my lord.
You are saying that judgment is 2010, thereafter 2012, something like that.
Yes.
But in 2013, you have clarified.
Yes, my lord.
Which
Definition of
indicates
nursing.
that the basis of the judgment has been removed, which is permissible under the law. The judgment you find out.
Yes, ma'am.
I think 1 or 2 months back,
I'll
1 month back.
We being that
I think justice, I forgot the other against the name of the judge, but this is
I'll
two bench judgment relying on the earlier judgment. It would be a letter judgment.
removal of the basis by the legislature or
Any-
and the executive.
Then this is basically by the legislature. Legislature, but then you can take the analogy also. Or the unless you challenge the authority of issuing the notification.
There'll be another aspect of the matter that clarification is only with regard to a particular office memorandum.
Yes.
Whether they will fall under the category of
No,
personal
that's what- that's
for
the-
all purposes.
That's the reason I'll hear you tomorrow again.
My lord.
Both of you find it out and read that and go on that. Otherwise, other things are not disputed, right?
Yes.
You are saying that had it not been this page 78
Yes, my lord.
by clarification, the petitioner ought to have would have entitled
Yes.
to the dress allowance as that of the nurses. Right? That is the crux, I think, which needs to be tomorrow.
Yes.
So we'll decide, you get that. That is latest one, but earlier judgment
Earlier
also, there's so many judgment. It is settled. So get that and argue tomorrow. We'll hear you. On this issue only. Facts are not disputed.
Yes.
Other things are not disputed.
Obliged.
Heard Mr. Majumdar, counsel for the petitioner. And also heard Mr. MS G. A. Learned CGC.
Yes, ma'am.
For the response. Hearing to continue tomorrow. 01 01/05/20.
That's the blessed.
Obliged.
Yes, yes.
May I please?
Yes.
Okay. This petition was filed for asking the standard rent of a house let out to the respondent. The respondent authority has taken rent of petitioner house for establishing a health center and provided only 250 rupees rent for 1 year. Thereafter, representation was filed. Valuation also been taken as standard rent.
Who is for the respondent?
Lordship, I am appearing for the respondents, for the health department.
Huh?
Lordship, I am appearing for the health department.
Yes.
Lordship, this matter has come after almost a year, Lordship, and only notices had gone. We would need some extra copies and we'd also need to intimate the department regarding this, regarding the present status.
Your what is your house has been given on rent?
Yes.
Huh?
Yes.
What is the agreement?
There is no agreement, in fact.
Then
Lordship,
what is the basis of your claim? Pay the petitioner standard monthly rent as fixed by the Executive Building Division for the rental house of petition from which the Bamun Pukuri Service has been functioning with effect from, and also to get the monthly rental with effect from 2014.
2014.
How much you are getting now?
Only 1 year rent I would get it. 1 year.
Deputy Council already paid.
Get to only 250 per month.
It's a matter of the contract agreement between you and the department. You take instruction.
Lordship.
2014 you got,
Only 1 month
it was
rent.
fixed for 250.
250 per
Are you getting now?
No, not getting, only
Did
1
well.
year, only
1
1 year
month.
rent,
Huh?
only 1 year rent I was getting.
1 year rent.
Thereafter.
At
rent
the
was
rate of
pending.
250 per month.
So,
Then when did you file this writ petition?
petition is
2023.
2023.
Then? After how many years?
Lordship,
Nearly 10 years.
Lordship, I was submitted various representations.
That that is being called by the Honorable Supreme Court as representation syndrome.
That's it.
Have you come across?
No.
Representation syndrome. We cannot encourage. 10 years we are filing representation.
They have also respond sometimes. They have submitted.
We
their
think over
their
it.
budget.
It's unnecessary. 10 years is too much. Heard Mr. So-and-so, learn concept for the petition. Mr.
M. Huya, Lordship.
M. Learned counsel for the
Health.
standing counsel.
No, Lordship. I'm appearing on.
Learned counsel appear on behalf of B. Go,
He
go,
go,
learned
Lordship.
standing for Health and Family Welfare Department. To obtain instruction as the claim made in this petition is for payment of rent, a monthly rent with payment of monthly rent as well as enhancement of the said rent.
As per
per the-
standard
As
rent,
per the standard. No,
standard rent.
as well
section
as
2,
standard monthly rent, payment of the monthly rent as well as standard
Standard.
monthly rent
monthly rent.
as fixed by the executive engineer, Jorhat PWD Building Division for the house rented, house provided to the respondents on rent for running of Bamun Pukuri Sub-Health Center at Jorhat. Jorhat, yes, just after 3 weeks. Doctor is such a.
Lordship, extra copy.
I will provide.
Opiate load to sign it sometime.
Only heard Mr. Johnson, Mr. The only prayer, Mr. J. Hendik, London State Council. This is method 3 weeks, so as to enable him to file affidavit of notice. Yes. Right, Lord.
Right, this is regarding a policy, my lord.
Huh?
This is regarding a policy, my lord, currently come to plus 20.
Policy?
Yes, my lord.
What
the
policy?
Builder system, PMJY policy, my lord.
Huh?
PMJY, Pradhan Mantri Jivan Bima Jyoti Yojana.
Yes.
Page 20, my lord.
Who is appearing? Any
PNB.
response?
PNB, my lord. PNB.
Hmm?
Punjab National Bank is the other respondents.
Service is complete.
Yes, name is shown in the was list, my lord. That's a PNB.
$48, $49,
52, my lord.
$52.
Yes, my lord.
SCPM. Heard Mr. M. Hussain, Land Council for the one appears for the respondent bank. List after 4 weeks. In the meantime, respondents to file their response. 4 weeks, we'll see. 3 weeks. You
My lord.
inform.
Date may be given if possible.
We'll see after 3 weeks.
How bless.
May I please, your Lordship? Lordship, I think it was ordered that 9/4/2025, where the Forest Department has asked to file their addition affidavit, but we don't know if that is the same Lordship.
Yes,
We'll file it in 2 weeks, my lord.
okay. But then if it is also in the forest land,
Yes.
what can we do?
So, no, Lordship, as per them, it is a forest land, but from whom we have taken the property is from list,
And
Well-
Mr. So-and-so, land counsel for the petition. On the prayer of Mr. I chose the land extending counsel, forest department.
I bought her.
I vote for.
I am for 1 and 2,
And Mr.
As bottom for 1 and 2, madam.
1 and 2. I vote for 4.
Forest Department. Lord.
Forest department. Correspondent number? Extending,
4.
Uh, 6 and 4, Lordship.
And Mr. S. Voter correspondent 1 and 2, huh? Next para. On the prayer of Mr. I vote for learned council for the learned standing council for forest department. Place this matter after 4 weeks, 3 weeks.
After 2 weeks, it
No,
can.
no. In the prayer of so-and-so, huh? Mr. I vote for learned council for learned standing council for forest department. But that a week's time is granted for filing affidavit. List after 2 weeks. Hmm? Hmm.
This petitioner is remailerless for 1.5 decades, my lord, only for mutation of his land, my lord. He purchased the land 1966, then 67 mutation was done and paid revenue. And suddenly 2010-11, he found that revenue is not collected because his name is deleted. Then he approached this authority, my lord. Then proceeding was done. It was not
before my
come to
friend
logical end.
proceeds,
My lord, this honorable court has
only my lord,
directed that to
only
give
thing, well,
just a minute, I just want-
respondent number 7 has expired. He is,
but-
he is pursuing a case against a dead man. He has to substitute.
Yes.
First of all, then the writ
I
petition has
understand.
not
Yes.
maintainable.
Well, we have not direct grievance, we have the grievance against.
No, their party.
Respondent number is 7 is the
but-
party and he has expired.
Okay, one thing, my
And
lord,
Mr.
construction is going on, my lord, to that effect, my lord, government may be directed to give, and we will take
On
the
the-
what needful we should done, my lord, a date may be fixed, my lord,
Yeah,
otherwise.
say that. Michael Jackson Barua. MJ Barua, Michael Jackson Barua. Mr. MJ Barua, learned counsel for petitioner, press for 2 weeks time to take steps for substitution of the
Respondent number 7.
respondent number 7, who reportedly, who has expired during the pendency of this writ petition.
And in the meantime, government may be directed, otherwise they are going on, construction is going.
What?
That is the impact.
Directed
My lord,
to-
one
Yes.
thing,
Directed to what?
To file everything, my lord, last. four
Yes,
occasions.
the state to file
Fine.
the response.
my lord,
Let them be fixed, my lord. And I have also brought some, my lord,
What?
synopsis, my lord, to understand this.
Do you think that this court has not understood anything?
for last
I understand, but
10 times this case was before this.
I cannot express all the cases, my lord. That is why I have.
I'm not too brilliant as like you. Therefore, we don't understand within a minute or a second.
My lord, he should not be left remediless, my lord.
This court is not brilliant as like you. So we cannot understand the case in a minute or second.
In both the cases, he has to substitute 56 and 57.
My lord,
In both the
name can be if my learned senior friend.
My lord, I do not know because
Yes.
I'm appearing for 4, 5,
You
6.
first take a
Let
step.
Well,
let-
then we should collect it.
May I please, your lordship? I
Yes.
just kindly place the order that is 16/12/2024, my lord.
16.
Yes, my lord. Actually, Westman has issued a notice, my lord. Whereby the construction of an accessory house undertaken with a petition of directed will start. No, if it is filed by the respondent, my lord.
Yes,
No so cause notice was issued, my lord.
stop construction.
Yes, my lord.
Where is that? Stop construction notice.
Actually, next, hi, my lord.
Interim is there any interim?
Yes, my lord. Is an increment.
Or Mr. Science, learn concept of the petition. Mr. J. Henry Learned State Council is granted for the 2 weeks time to file a.
Lordship, my lord, I appear on behalf of respondent one only. 2 and 3, my lord, they have a separate, my lord, they are a
You
this is a, my
inform
lord,
them
municipal board.
that learned council for the J. Henry learned council for the
Respondent one.
state council for the learned state council for the respondent number 1 and other
They-
respondents
Whether the service
granted.
has been completed or not, my lord.
are granted for the 3 weeks, 2 weeks time to file their response. You kindly inform.
Okay, my lord, municipal board, lordship, we cannot appear.
You inform them.
Lordship,
Actually, implemented per service.
Earlier, inform the first earlier. Yes,
lordship, my lord, their name, lord, somebody, appear to say.
the name of the learned standing council for what?
Eh?
GMC.
No, no, lordship, it is a Gauripur Municipal Board.
Municipal,
Sir,
respondent municipal, be reflected in the post list. Or you say, registry to reflect the names of the learned standing council for Gauripur Municipal Board. Respondent number?
Respondent 2 and 3.
2 and 3, lord.
2 and. Yes. Have you filed the affidavit?
No,
You are for respondent number 2.
no.
You have filed it already. Not appears for the petition on call. Affidavit in respect of respondent number 5 has been filed. List after 4 weeks. Affidavit. Yes.
Well, we have written to the department. There are several other repetitions of.
Mr. So-and-so, let me consider the proof. For the 3 weeks time is granted to the Mr.
A. Bhattacharya.
A. Bhattacharya, Learned State Council to obtain instruction.
What's up?
Yes.
Lordship, this is land acquisition matter, Lordship.
Hmm.
The land of the petitioner was being acquired by the respondent authorities, Lordship, for building of that bridge, North Guwahati Bridge.
Hmm.
Lordship, there are two dark numbers are there, out of which.
519 you have received.
Yes, 519 already
Present
received.
case relates to
That is
number
also
6,
reflected in the order dated 3/1/2025, Lordship.
366 only.
Yes, Lordship.
You have received?
I have received 519.
Yes.
And that is also reflected in the order dated 3/1.
Yes.
Just after filing that, I have received that.
Okay. Now whatever 366, yes.
They had acquired long ago, but
When?
when the construction started, Lordship, in
2018.
Yes, Lordship, but then I will require that interest also, Lordship.
And let's try to get the principal.
But interest also is. They were supposed to pay in the year 2018, Lordship.
Lordship, that instruction that I have filed.
You file an affidavit, what's there?
Lordship.
What does it say? The student of share of land remains, he's a case
360
applied officer not going to report inward release of-
1%.
Yes. Have you applied? Says another bigger has been the acquisition. Huh?
Let me bring it on record.
Record, Lordship. Let him bring on record, Lordship.
No, what they said, you approach the circle officer for release.
I have given the presentation, Lordship. I have annexed also.
Okay,
Annexed
it's up to you.
page 91.
But MSD goes, then counsel for the petitioner. Mr. J. Hendrik, Learned Council, Learned State Council, Senate State. By placing the communication, that copy of the communication with 2701 2024, Senate State. LA compensation in respect of DAG number 366. Come on. The petitioner may approach the release of the compensation in terms of the release of the compensation. How about he submits a press for placing the bring on record the communication, every communication by affidavit. For the 3 weeks time, 2 weeks time is granted to the London State Council to bring on record.
After accounting money.
Communication is spread. 3 weeks.
3 weeks.
Lordship, I'll humbly pray for fixing a date, Lordship.
No, because I think you have just simply filed a reference will provide in the meantime. No, having considered the submissions of London State Council, the petitioner is at liberty to approach the circle officer.
Lordship.
In the meantime. You approach once again.
Okay.
You share the copy of this.
Lordship.
Let him bring on record, I'll file my.
No, you,
Oh,
in
yes,
the meantime, you go and approach, ask the petitioner to approach.
Yes,
It's clearly said, we approach the circle officer for release.
Yes, Lordship.
Clearly mention the DAG number also. that
Yes,
number.
Lordship.
May I please the Lordship?
Yes, sir.
An amendment application paying for changing the address of the respondent number 5, Lordship.
Where is that? Yeah.
Yes, Lordship.
That's. Where is the IA? Respondent number?
5, Lordship.
Who is respondent number 5?
5, Lordship. Project manager, Corsian Corbian Construction SA, Lordship.
Heard, Mr. Sir. Any objection? No. 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 Heard, Mr. Learned counsel for the petition and also heard applicant
2 and 4.
and Mr. C. Barua.
For 2 and 4, my lord.
And counsel for respondent number 2 and 4. By next paragraph, filing this application, the applicant has sought for amendment of the address of the respondent number 5 in connected WPC 8847 of 2018 by incorporating the correct address.
Address, Lordship, paragraph 4, Lordship. Of the IA application.
Earlier it was wrong address.
Yes, Lord.
Mr. So-and-so, learned counsel submits that the petitioner has inadvertently incorporated the wrong address of the respondent on the file. And the writ petition is to be for. It submits that the applicant may be allowed to incorporate the correct address of the respondent file by amendment of the post title in respect of the respondent file. Next one, having considered the submissions. Learned counsel for the applicant. Now, perusal of the application, which indicates that the applicant appears to have wrongly incorporated inadvertently incorporated the wrong address in respect of respondent number 5 and connected with petition being WPC so and so. And as well as prayer not being objected to by learned counsel for the respondents. I deem it appropriate to allow this application accordingly. The present application will be allowed. And the applicant is allowed to amend the address, amend the post title by incorporating the correct address. Page 9, huh? No. Page 8. Para 4. Example. MS so and so, not the entire paragraph, but only the address, the name of the party makers. The application to higher instance allowed and spell them. So you will have to file amended post title. In view of the other past, the ISO and so, we learn consent with the petitioners to file amended post title. the registry to incorporate the same and issue notice. Petitioner, land consumer petitioner to take steps.
Lordship.
You file first, amended cost that
Lordship.
they'll incorporate, then you take steps.
Highly obliged.
May I, Lordship? Lordship, respondent number 5 has filed an affidavit in opposition. Lordship. We want to file reply, Lordship.
Huh?
We want to file reply, Lordship.
What is IA for? IA for?
IA is for Lordship.
You are not pressing.
That's it.
You are not pressing. You are not pressing the IA.
Pressing may be taken in
Huh?
next date, Lordship.
Okay. On the prayer of Mr.
Ex-gratia, Lordship.
Learned Counsel for the petitioner.
Petitioner.
For the 2 weeks time is granted to file affidavit in reply to the affidavit of filed by the
Lordship,
respondent
there's-
number 5.
Yes.
Respondent number 5.
Respondent note.
Yes.
There is interim order, Lordship.
Interim order pass and let's continue.
Nevertheless, as per office to date 25/4/2025.
Huh?
25/4/2025. Office to date neither etiquette nor answer.
Office no heard Mr. So-and-so learned counsel for the petition. Office note dated 25/04/2025. Reflects that neither etiquette nor answered notice have returned back. Yes, in that case,
So we have take step on, 2 times we take step.
press steps.
Lordship, I have already take step for 2 times, but it was not returned back.
You find out, then you find out.
The officers is there, Lordship. As far information, the officers is there, Lordship.
Officer,
The contaminants is there, Lordship.
so,
They are holding the post, Lordship.
so. Then you take press steps again.
Lordship.
Although the petitioner submits that he has taken steps twice.
Only twice, on
Further
25/9/2024
a week's
and
time is
24.
granted to the land council petitioners to take press steps.
So I recorded with earlier take step on 25/9/2024 and 24.
Yes, I have noted that.
Twice, Lordship.
Twice you have taken, but then
Obliged.
you take again. No notice for the petitioners. Yes.
Lordship, initially a notice was issued for unauthorized construction, Lordship,
Hmm.
asking for NOC and other documents. Lordship, when this matter first time came up, Lordship, it was on 3/8/2022. Lordship, may kindly see that order has been annexed in the IA, Lordship.
I is by you.
IA by the petitioner herself.
Non-appear will not consult. Non-appears for the applicant of the great petition. Mr. P. Leonard, State Council.
Standing Council, GMC, Lordship.
Huh?
GMC and GMD.
Standing Council. Standing Council, GMC.
Yes.
And GMD
Both, Lord.
is present. List after 4 weeks.
Well, we have filed this amendment petition, Milord, because from the affidavit filed by the corporation, we came to know, Milord, the letter of appointment as a dealer was given. So basically, we want to bring that to challenge. That letter is at page 291, Milord. 291 and 287.
Writ petition.
Yeah, no, my lord, of the IA.
Hmm.
287 to 288.
No,
Asa, their affidavit is there, my lord. 287 is the LOI
Hmm.
and 291 is the
Hmm.
order of appointment as a dealer.
So you amendment in which
We would
para?
like to put, yes, sir. We'll file and after following your lordship's order, we will have to file a consolidated petition.
Ah. In the prayer portion only.
No, my lord, we'll have to make, no, we'll have to make one or two amendments that we have already prayed for, my lord.
Right, sir.
Para 8. Page 8 of the IA.
Para 8 to 17 over. Para 8 to 17 over.
Now, my lord, para 8 to 17, it will have to be inserted. Para 8 to 16, actually.
Any objection?
No, only my objection may be recorded, my lord.
What objection?
Since when I am appearing for a corporation, my lord, only my objection may be rejected.
What is your objection?
For sake of the objection, my lord.
No, that will be.
Because my
detrimental.
says the character of the-
Be recorded for the sake of objection. Anyway, and Mr. K. Chodri, Senior Counsel.
For my beneficial, my
assisted
lord.
by- Yes, yes. Persons, let me counsel for the petition, applicant, writ petitioner. And also heard Mr.
Yes, protocol.
Correspondent number
226, my lord.
2, 2, 2, 3, 4, 5.
6, my lord. He is for 7 next.
I'm for 7, my lord. Everybody charging for 7.
And Mr. Swain.
Everybody charging for 7.
Correspondent. And which for 1?
No, Mr. Assessor was appearing, lord. Mr. Roy was appearing, lord. Mr. Assessor was appearing, lord. CGC.
Non-APS providers. Next paragraph. One, desperate solution. By filing this application, the applicant has sought for amendment of amendment in the petition, the WPC 377 of 2021. The reasons and the reasons for the proposed amendments are quoted here in our para 8. Para 8 to 16.
Yes, my lord.
Although Mr. S. has raised objection to the amendment sought from this court, having considered the nature of the grievance raised in the petition. In the connected writ petition, of the view that the IA contains the grounds to be allowed, grounds and reasons to be allowed.
And my lord, we may also be allowed to lay challenge to this 287 and 291. One is the letter of intent and other
No,
is
once
letter of.
once we allowed the amendment,
Yes,
where you have mentioned that
in the prayer, my lord.
challenge. And also prayer person will say,
Yes, yes.
along with the prayer person. Huh? Mr. Accordingly, in the interest of justice, the present application is allowed. And accordingly, the applicant is allowed to amend the connected with petition as read above. ISPs allowed and disposed of. That's all.
Yes. My lord, since it's a 2021 matter in the first week of June. First week of June, my lord, the matter will be in the meantime, we'll file our, my lord, consolidated writ petition.
In writ petition, in view of the order passed in ISO and so, the petitioners to file consolidated writ petition. If list after. When?
June, first week of June.
In the first week of June 2020.
Deep Lord.
Demolition.